and very warm welcome to this session, Finance Bill 2024. Uh, the central theme of this year's budget seems to be simplification and rationalization of the tax provisions. And in fact, the Honorable Finance Minister has set the ball rolling for a complete overhaul of the income tax laws that are at present we are facing with. And in fact, in this budget itself, there are several measures have been taken for simplification and rationalization of tax provisions, such as there is complete change in the assessment or reassessment process, capital gain provisions, and so on. Some of the tax provisions have even been omitted or repealed. For instance, equalization levy on e-commerce transaction and angel tax, that these significant provisions are proposed to be done away with. Now, while the theme of the finance bill is simplification and rationalization, but as we see it, the provisions of the finance bill do present complexities, and there are several nuances and niceties which are involved, and which need to be deliberated, and which may have some far-reaching implications. So we have with us eminent jurist and the lawyer, Mr. Ajay Vora, senior advocate, who would be giving his expert comments and on the changes in the budget proposals. Then we have, and then the panel essentially does not require an introduction. Arun Giri, the Tax Sutra man, so everyone is familiar with him. So he would be moderating the session for today. Then Rohit Jain, my partner, my friend, he is an expert and authority on direct tax and corporate tax matter. And both of us shall be dealing with the direct tax proposals in the finance bill. And thereafter, my other partner, Mr. Shami Kapoor, and his team, they'll take over to deal with the indirect tax proposal in the finance bill. So let's begin with our discussion. I'll hand it over to Arun.
Thanks so much, Neeraj ji, and it's wonderful to be among you all. I've come to Delhi after a while. I last came for the Tax Sutra conclave in May 23, so it's been quite a while. A pleasure to be among you all. Ajay ji, Rohit, good friend, Shami is here, the Vaish team. You know, whenever I talk about my first interaction with Vaish was when I just quit my broadcast journalism. I was in CNBC and then Bloomberg. And straight after CA, I did journalism. So when I quit TV after 7-8 years in 2011, and we were about to start Tax Sutra, and I read somewhere Asia Sat ka judgment hai. So I called up a good friend, and he told me that Vaish ka matter hai. You should call up their team, and I somehow got Ajay ji's number. And I called him and said, sir, this is Arun Giri. I have not spoken to him before. Said, sir, this is what I heard. He said, yeah, but the judgment should be out. It's been pronounced. And that was my first interaction with him. And what I've always carried, whenever I've interacted with Vaish partners, with Ajay ji, with everyone, is the warmth. And I'm sure that if the house is, if the hall is packed at 10:30 in the morning, it's because of the warmth you feel when you interact with the Vaish team. You know, they work so hard. They are one of the premier law firms in the country, and it's a pleasure to be moderating this panel. I love to do this every year, and which is why I'm here from Mumbai. Someone sent me a photograph of Lonavala. It's raining incessantly in Mumbai and Pune over the last few days. Tough call whether I would rather be in Lonavala enjoying the rains or here. But after meeting you all, I think I made a wise decision to come here. Looking at the budget itself, I was just thinking this morning, whenever you stay in a hotel, you get up at 5. उसके बाद नींद नहीं आती है. I said कि यार कौन से 2 budget हैं, 20 years of budget, and I started with CNBC in 2004. Which are the budgets that I recollect? Only 2 came to mind. First budget you never forget, because that's your first budget. So that was 2004. Again, an interim budget. Mr. Chidambaram presented it, and the reason I remember is because of fringe benefit tax. It caused a furor, and it eclipsed everything else in that budget. The second budget I recollect is 2012, the year after we started Tax Sutra, because of the retrospective amendments. And even as the budget speech was being announced, I had written an article the day before, 5 things to watch out for in the budget. And I said, watch out for retrospective amendment for Vodafone. And in the speech, the finance minister, Mr. Pranab Mukherjee, did not speak about the retro amendment. I messaged one of my sources and I said, sir, nothing has come. And I got a smiley in return. So then I understood, finance bill to dekhna padega. And I told my partner, I said, ki boss, tu finance bill aate hi dekh le. And he shouted after the finance bill came at 1 o'clock, Arun, the retro amendment is there, Vodafone retro amendment. And we sent the breaking news. Lo behold, I don't think anyone in our team slept that night. That is the number of retrospective amendments were there in 2021. So those are the 2 budgets that come to mind. Every other budget, though we may discuss here, but I forgot. This budget is one which we'll remember after 10 years. Because you've made structural changes after a long time. Be it capital gains, be it angel tax, be it a little bit with reassessments, or the announcement that we are going to come up with a comprehensive relook at the Income Tax Act. We'll come to that later. But this is something that we'll keep in mind, because you've done something so structural, not just capital gains, but so many other provisions, doing away with equalization levy. So many provisions which are structural, which is why I think 10 years down the line, we may think, yeah, kaun sa budget last 10 saal ka yaad hai? We'll say 2024. It's one of those budgets, and which is why I think we have so many of you coming here to understand what this is all about. Something that I found very, very interesting, and I was watching the speech with intent. I was on Z Business for 4 hours, and I was watching it with intent. I had the last 2 years' budget speeches with me, 23 and 22. And I said, ki compare karke dekhte hain. The last 2 budget speeches were all about 2047, Vikasit Bharat, Atmanirbhar Bharat. 3rd minute of this budget speech was about employment and skilling. 3rd minute. The last few budget speeches, 20 minutes was about how great we are. I mean, everyone claims that. I'm not saying no, every finance minister will do it. 3rd minute was employment and skilling. And I, for one, felt that if after the election results, ministers haven't changed, portfolios haven't changed, the bravado is still there. So election result, it seems they have actually won 20% seats more, not 20% seats less. The budget is the first time in the last 45 days that we have seen that reality has dawned upon the government as well. Unless you look at the speech and some of the amendments from that prism, I don't think we'll understand the budget and what is to come for the next 5 years. We are not here to only understand the amendments to the budget. I think it's also important to understand what will economic policy be looking after the next 5 years. Because if I spoke to some of the senior bureaucrats a couple of months ago, they were like कि पहले 4 महीने में कौन से bills आने हैं हमको मालूम है. The bills are ready. Now you will see how many of those bills actually come to the floor of Parliament. How many of the bills undergo a change? Only one bill has been announced that they will come. They'll come with it. And that is a major overhaul of IBC. But we've not heard anything else. So I think the budget is just a start. I mean, forget the special packages for Andhra Pradesh and Bihar. It's nothing new. It's been done even in yesteryears when there was a coalition government, when Mr. Lalu Prasad Yadav was a railway minister, or Mr. Nitish Kumar was a railway minister. A lot of trains used to run from Bihar. So those are things that we've seen in the past. But the fact that the budget speech in the third minute or fourth minute focused on employment and with no talk about 2047 Vikasit Bharat or any of the other slogans of the last 2-3 years also speaks volumes of the fact that the government also understands ground reality. I did exit poll. This tax journalism, whatever I am doing, is purely because I have no choice. But my passion has been polling. And I did exit poll for 8 seats in Maharashtra. And we got all 8 right. Whoever follows me on Twitter would know. So we asked a question, and I went to some of the constituencies in rural Maharashtra. And I asked, what is the main issue for you while voting? And I had given a list of issues. And the 2 biggest issues that people said was number 1, price rise, the number 2, unemployment. And I still remember one lady, she told me that we get 20 minutes water in a day. That's it. One of the villages in rural Maharashtra. 20 minutes water in a day. That's what we get. I think some of the things that you're seeing in the budget is a reflection of that sentiment. And which is why I think the economic policy, whatever you see over the next 5 years, I think if history is any guide, the focus on tax collections will be even more hawkeye. It will be as sharp as Arjuna's or Karna's aim at the target with the bow. Because none of these things can be done without robust tax collection. Look at the graph over the last 22 years. From 1 lakh crore tax collection, direct tax in 2001-2 to 18 lakh crore net tax collection in 2023-24. And for the first time in 23 years, the personal tax collections have crossed the corporate tax collections. From a 2 lakh crore gap between the two, or roughly, you are now at 50,000 crore reverse gap. 9,72,000 crore personal tax, 9,25,000 crore corporate tax, and with a lot of room to grow. If the government has to fund a lot of these welfare schemes, maybe be even more, be more brave in terms of whatever doles they have to hand out, or whatever future schemes they may want to launch. 45 days was maybe too short a time to launch something ambitious. The last time you saw a very ambitious social welfare scheme was Narega. So if you have to launch something so big, you will need tax collections to be in place. And I think my personal feeling is whenever you need those welfare schemes, big handouts, there is an equal focus on tax collection. Before handing it over to Sir and the partners for an initial reaction, I thought on structurally 2 things to be pointed out, which I don't know how it will play out. One is the ease of collection. Out of the 22 lakh crore gross tax collection, and I was looking at the time series data, out of the 22 lakh crore direct tax collection, 20 lakh crore is coming out of TDS and advance tax. Extraordinary. Look at the convenience for the tax administration. Extraordinary. And 20 years back, I still remember I was in CNBC and I got a red carpet welcome in the income tax department. And even today, CNBC is using the same shot of the department which I had shot 20 years back. And the commissioner welcomed me. I remember the name, Mr. Rajiv Ranjan Singh. He welcomed, he said, I am in charge of salary. this is what we are doing. We are going to be technology driven and this and that. Our focus is going to be on TDS. Though I had cleared my CA final, itna TDS वगैरह, I was not so well versed with that. But he said TDS पे हम focus करेंगे, देखना. And 20 years down the line, TDS and advanced tax are contributing to 20 lakh crore out of 22 lakh crore of tax collection. Incredible. Incredible. It is essentially giving the tax administration so much time for other things. Be it scrutiny, be it assessments, be it reassessments, so many other things. Analyzing the data. We think that the digital data analysis and everything, is easy. We are into content. It's one thing to have the data with you. It's another thing to mine it. And which is what I expect the department will do over the next 5 to 10 years. You have the data, now you analyze and mine the data. That's what is going to happen. And the second thing, second point I thought is structurally, what is unchanged is the litigation pileup. Bombay High Court, you are hardly having any final disposals. Cases, income tax cases as far back as 15, 20 years have not come up for final hearing. Supreme Court, set satellite, such an important case, 16 years it's not come up in Supreme Court for final hearing. It's supposed to come next week. We were just discussing before the session started. Structurally, assuming the income tax code gets overhauled, for it to actually, assuming it's easy to understand, easy to comprehend, lucid, these are the things that the finance minister said. Easy to understand, easy to interpret, lucid, concise. Let's assume it's all of that. Assuming it's the best income tax code ever written. If God has written the code, let's assume. For the effect to kick in will take 15 years. Assuming that all the litigation gets cleaned up in 15 years. It's a structural issue which I don't think, unless you follow Supreme Court like we do for a living every day, day in and day out, we have 3 people only following Supreme Court. The structural issue bogging us down on the litigation side is so enormous that anything that the government does on this score will require another 15 years to bear fruit. And I think the voters have made it clear, no one is interested in 2047. No one is interested in Vikasit Bharat after 20 years. लोग बोल रहे हैं 25 साल बाद हम कहाँ रहेंगे हमको मालूम नहीं. You talk about 2027 and not 2047. Whatever you see over the next 2-3 years, I am not envisaging any further mention of 2047. No mention of 2047 even once in this speech. You will see a government which will be focused on 2027 because the UP election is in 2027. Joking. On that note, I hand it over to... Surely. So on that note, first I'll seek, the initial comments from Ajay ji. Hope I did not cross any lines, sir. But I thought I'll give a different flavor. Right. Otherwise, you've heard everything you had to hear about the budget.
Right. I think, Arun, on your point that you remember only 2 budgets, I think speaking for us, we look forward to every budget. Because it creates new opportunities, new litigation. And the audience here is actually a repeat audience, and I see several faces which I've been seeing for several years.
Yeah.
Because it is our job to understand every budget, understand every provision. Right. So, in fact, as we speak, the other day, the day the budget was being presented, I was getting your flash in the court of this has come, that has come. So the reassessment provision came, and I was arguing a writ against the reassessment. So I told the judge, see, today we refer to the old regime, which is pre-1421. Post-1421, we refer to the new regime. Now we'll have a newer regime.
Yeah.
So I think this tinkering in the budget every time, while there may be some sense in it, creates unnecessary uncertainty and unnecessary litigation. And litigation has a cost, there is a time. You mentioned about matters pending in the Supreme Court. I think I tell people today that a life cycle of a matter till the Supreme Court is 35 years. I expect it to go up to 50 years if this is the pace at which we will dispose matters. So that's why you have a Vivad Se Vishwas 2024. You are raising the limits for filing appeals by the department. That's the only way in which you can solve the litigation areas. But people who are stuck are absolutely frustrated at the delay in the system. So I think that's one important point. The second you said about TDS. I think if you look at developed economies across the world, you see the tax system is meant for voluntary compliance. The entire administration, and you said only 2 lakhs crores are collected, and look at the cost of administering from the assessing officer to the Supreme Court. Everyone is involved in this collection, which is possibly in your calculation 2 over 22 is probably less than 10%. I would think it would be 5. I would think that would be 5. The successful rate at which they can collect taxes after matters are disposed by the Supreme Court may be less than 5%. But the tax system is meant to be a deterrent. And I was speaking yesterday to Mr. Chopra, and I think Mr. Raman Chopra, the JSTPL, who was responsible for formulating the budget, when we talk of comprehensive review, he says, don't think that we will replace the act. He said, we have a definite 6-month time frame. All that we'll seek to do is clean up those sections which are redundant. We might bring in some rationalization of the provisions, but it is not going to be a wholesale replacement of the Income Tax Act. So that's what he indicated, that there are several sections which are today dead letter, which we'll seek to remove from the book, and we will try to somehow streamline the processes. So I think that's the other point that he made.
So when it comes to income, sorry. When it comes to income tax, when it comes to income tax, even a dead man can rise from the grave.
Second, I think when you say that there is substantial increase in personal taxes, I think this has to do with the kind of information that is coming to the tax department. You have so much information that is flowing from different directions. And our advice to people is you must voluntarily and diligently comply with your taxes, because the sources of information are infinite. In fact, I often tell the judge in the court that there is so much unproductive litigation because there is information that is coming but not intelligibly mined. You said mining the information. I am adding the phrase, it should be intelligibly mined. A foreign company investing in a subsidiary, a notice is issued under 148, of course, for our benefit, because we litigate and we get the notice quashed. But look at the message you are sending to the outside world. You need to sit down and intelligibly mine whether this can amount to escapement of income. So while we may get information, what you need to put on the ground is people who understand, who can intelligibly look at the information and reach a rational conclusion. Otherwise, you will only be spawning litigation, which will serve nobody's purpose. Ultimately, it frustrates the taxpayer, it frustrates the system, it clogs the court. So I hope with that few comments, we look forward to a rationalization of the provisions in the right direction, in the right approach towards administration. And I told Mr. Raman Chopra yesterday, you shouldn't be changing the law. All that you need to do is tone the administration. You need to revamp the administration, make them responsive, make them responsible, make them educated so that they understand what they are actually required to do. Thanks, Arun.
Mr. Vora has been talking about toning up of the administration and so much of clogging at courts. So that reminds me, the finance minister, the honorable finance minister, did mention that there is a clogging of appeals at first appellate level, and from our chambers, my friend Rohit Jain has been making all effort. Making representations to the ministry. And then finance minister did react to the requests, and she'll be deputing more bandwidth to liquidate these appeals, which I understand are more than to the tune of about 5 lakhs appeals pending at first appellate level itself. So if those appeals were to be disposed of on a fast-paced or faster-paced basis, so this will clog our courts. I think it'll even further. That Rohit may have some initial comments to make.
Rohit, any couple of amendments that caught your eye? Which is your favorite amendment?
So one major amendment when we will, so just to supplement what sir said, we are talking of pre-amendment, post-amendment, newer amendment, and we will also be talking about block assessment. So when we will be taking you through block assessment, you will find that it is more draconian this time than it appears to be, and you will find that there is something we say on a lighter side, people who practice issues relating to such, that there are two things which are certain. One is death, second is tax. And in tax, one is what is certain is search. And if search happens, then you are faced with block assessment. So I think they have complicated the things. Unnecessarily changes have been made. I would say there seems to be some confusion, because in 2021 itself, you revamped the entire process. You did away with 153A, 153C, brought back 147. Now you are again, dismantling the entire process, coming out with a new process. And in that process, you are actually, the provisions are not, properly drafted. That's what I would say. And then I think when we will discuss the fine prints, it will be better to, go into the nitty-gritties.
See, when we run at Taxutra, our company's name itself is real time. It starts with the prefix, because when we registered with the ROC, they said ye naam nahi denge. You have to prefix it with something. With taxsutra.com humne diya tha. So we said we'll make it real time. We did not know that we will really stick to that ethos. So when the economic survey came, we first did a search कि tax कितने बार mention किया, बाकी गोली मार दो जो survey में है. 98, 99 times वो mention हुआ था. So it's very surprising. The economic survey made a mention that one of the things that's a downside is the uncertainty in transfer pricing. Actually mentioned it and said that we need more safe harbor, better, so on and so forth. And second, again going back to the political part, just remember one thing, that the government or the party in power, the 5 biggest states in the country which sent 250 MPs, they have lost 4 out of the 5. You have one of them going to election now in October, Maharashtra, which is my state. Do remember that electoral outcomes could lead to a confused legislative policy in the next 2 to 3 years. If the outcomes are not in favor of the party in power, it leads to constant second guessing by the party in power. What do we keep changing? That's what a defeat does. So remember that whatever the finance minister says will get tested after every 6 months when elections happen. And it could lead to a confused legislative outcome, which is what we saw between 2011 and 2014 of UPA 2. Defeat after defeat, and then you had the spate of retro amendments, undoing of them, then undoing 3-4 years later. All of that led to 5-6 years of policy chaos. So I'm just saying these are the downside risks, not that any of this will pan out, just the downside risk. On that note, we hand it over to Neeraj.
Now we begin with the fine prints and go clause by clause so far as the finance bill is concerned. I shall take up some of the amendments, and thereafter Rohit shall take over. I shall quickly point out the amendments which have happened to the tax rates. So for assessment year 2024-25, there are no changes in the rate. In assessment year 25, for assessment year 25-26, rate of changes are only as under the new regime, tax regime, which is as per 115 BAC. And for domestic company, there is no there are no change so far as tax rates are concerned. Foreign company, of course, there is a reduction in the tax rate from 40% to 35%, and then there will be surcharge and education cess which will be added on to this. So far as tax slab is concerned, the tax slabs for old regime continue to remain the same. In the new regime, however, there is a slight change. In a sense, as you must be seeing, for assessment year 2025-26, the first slab remains the same at 3 lakhs. The second slab, there is an increase of 1 lakh of rupees from 3 to 6 lakhs. It is increasing to 3 to 7 lakhs at 5%. And then this change is percolating downwards for the subsequent slabs. So this is, and let's see how does it impact. So here is the comparison. So under the new regime, now tax rates would be slightly lower again, effective tax rate. So for up to 10 lakhs, it is 5.20%. Up to 7 lakhs, in any case, there would not be any tax after rebate under 87A. And while under old regime, there will be tax of 7.8%. And the comparison can be seen on the screen. Now, this was, so far as tax rates are concerned, there is a marginal increase in the standard deduction under new regime from for salaried class from 50,000 to 75,000. And then these are some of the changes. So this is the impact. We have done some examples. So under the old regime, if the gross total income is up to 7 lakhs, so the tax liability would work out at 10,000, while in new regime it will be 0. At a higher income slab, say if individual were to be claiming a HRA benefit or LTA benefit, under the old regime, with a salary income of about 20 lakhs, in the old regime, the tax would be 2,40,000 because of HRA and LTA benefit which he is availing. And in new regime, it will be slightly higher at 2,86,000. Likewise, without HRA, of course, the new regime would be more tax effective, and it will give a lower tax incidence. So when income were to be increasing even further, we see similar kind of result. And with HRA benefit, old regime gives a tax incidence of about 3 crore 60 lakhs, where the income from salary is as high as 10 crores. And in new regime, it is slightly higher at 3 crore 87 lakhs. And without HRA, the tax incidence would be lower in case of new regime. Now, one of the major significant changes which has been brought in the finance bill, in this budget, is rationalization of capital gain taxes. And what the Honorable Joint Secretary said, that it was popular demand, and people were all the time seeking rationalization of capital gain tax provision, and that is what they have sought to do in this finance in this year's budget. So there are three major components of changes in so far as capital gains taxation is concerned. So holding period has been restricted to primarily two holding period. So 12 months and 24 months. For most of the assets, the holding period of 36 months for characterizing a transaction as long-term capital gain. giving rise to long-term capital gain has been done away with. So an asset would be a long-term capital asset yeah, if it is held for 12 months or 24 months, as the case may be, except one kind of transaction, which is the transaction of sale of undertaking, slum sale of undertaking. Now there is a separate code for taxation of undertaking by way of slum sale, which is section 50B. Section 50B specifically prescribes, the holding period of 36 months for characterizing the transaction or the transfer as long-term, giving rise to long-term capital gain. There is no amendment in that section. So for transfer of an undertaking by way of slum sale, the long-term gain would be characterized as long-term if it is the undertaking is held for more than 36 months. The second component of change so far as capital gain is concerned is tax rate rationalization. So broadly, the tax rate has been brought down or maybe increased in some cases to 12.5%. So the indexation has totally been done away for all kind of transactions. Indexation is no longer available. Indexation benefit is no longer available. So now, as you see from this table or this matrix, that the changes would pan out like this. For unlisted share, STT under section 112, where STT is not paid. In the earlier scenario, the holding period was 24 months for long term. Now it remains at 24 months. But tax rate would come down from 20% with indexation to 12.5% without indexation. Then for listed equity share, unit equity oriented mutual fund, a holding period is 12 months, which remains 12 months, and tax rate would increase from 10% at present to 12.5%. So in this case, there is an increase we are seeing. Now listed bond and debentures, again tax rate is increasing from 10% to 12.5%. Units listed business listed business trust, REIT and NVIT, etc. Again, tax rate is increasing from 10% to 12.5%. But here, the holding period for characterizing as long term is coming down from 36 months to 12 months. Gold, likewise, from 36 months holding period, 36 months to 24 months. And tax rate would go down to 12.5% from 20%. Immovable property, again, the tax rate would come down. So from 20%, now it is 12.5%. So far as, and there is a basic exemption for section 112A transaction on STT paid equity shares. So earlier, up to 1 lakh, tax was not required to be paid. So this exemption has been increased by 25,000 to 1.25 lakhs. So far as short-term capital gain is concerned, equity shares, unit oriented mutual fund, etc., which are STT paid, the tax rate is increasing, in fact, from 15% to 20%. And this second change, this is also a significant change impacting people. Holding period in case of unlisted debenture and bonds used to be 36%, and then the asset or transfer would be giving rise to a long-term capital gain. Now it has been completely done away, and in terms of section 50AA now, this gain arising from transfer of unlisted debenture and bonds would be deemed as short-term capital gain, and therefore it will be taxed as per the tax slab rates in the hands of the recipient, in the hands of the person earning the capital gain. Instead of earlier, the rate was 20%. So this is one of the significant change which is happening, and which may be impacting people. So these were broadly the rates.
I'll just take a dipstick. How many you all have largely understood this provision, beautifully explained by Neeraj. Personally, how many have been affected negatively by this? Me also, with regard to my personal property.
So one could see gloom on many of the faces. So I think.
Can I ask a follow-up? Earlier slide. How many here are filing return under the new regime? Thanks.
FMC 53%.
64. 64.
So one question on 50A, so there is a grandfathering when the 53 AA came, last year budget, and they allowed the indexation on the old investment up to 31st March 23. So is there any clarity whether that would be under the long term at 12.5% or a short term?
There is no grandfathering.
There is no grandfathering. While it was grandfathering last year, they were going to grandfather this time.
Correct.
I think not that they are forgotten, I think it's conscious.
Conscious.
They are defending the position, saying that we brought down the rate, and of course, for unlisted bonds and debentures, they have deemed it to be short-term gains and taxable at slab rate. But I think the intent is to tax it at that level.
Because last year they grandfathered and this time not, while there is simplification in the scheme,
Right.
but still I think it's worth maybe giving that thing because
The concept by with they are working is that the taxation incidence happens at the time of transfer, and unless there is a specific provision for grandfathering, which was there in the last budget where they said that 2023 units acquired prior will still be governed by the old law. So
And
unless there is a specific grandfathering, you will still be governed by the new law. And their case is that we have rationalized because if you read the newspapers and the statement which are made by Revenue Secretary and the Finance Secretary, they are saying that we are rationalizing it. It might hurt someone, it might not hurt someone.
You see, as while Rohit is explaining the rationale, but as we all know, and Finance Minister also indicated that tax and equity are strangers. So if they are seeking to tax it, they are seeking to tax it, and if they are seeking to tax it at a higher rate, then you have to bear with it.
I'll make a personal.
That may arise. One question that may arise is that if your unlisted bonds or debentures were acquired with a certain rate of return, with a certain taxation scheme at that point of time, now if they are redeemed post 22nd July, they become taxable at the slab rate. Now whether this can be challenged in a court of law as being on the ground of promissory estoppel, that at that time when I invested, this was the rate and it had a period of maturity of, let us say, 36 months. Now you've changed the rate and it becomes taxable. So it's an open question whether the courts will bite into this and say that the legislature does not have the competence to enact such a law.
In fact, yesterday someone was telling in terms of numbers that most of the people invested when this new budget proposal came in from April 2023, and most of the people invested because they were giving a fixed return and they were still governed by the old law where you have the benefit of indexation and you pay a lower tax.
Right.
So the effective yield which he was saying was 6 or 7% they were issuing, and the effective yield was around 6.5% and more. But with the new budget and they invested it, and there is a you have to be there in that 4 or 5 years. You can't exit that option. Now when you exit now, your yield actually will come down by 2 or 3%, and which will be lower than even the the interest which is being offered by banks.
Correct.
So that to buttress the point that actually it is because they invested with a promissory estoppel that they will be governed by a particular regime,
Right.
where their yield will be a particular rate. Now because of this amendment which is affecting them also, the yield will actually substantially come down. And it will even go down below the bank rate also.
Right.
Rohitji, I think they have made the sovereign gold bond more lucrative by two reasons. One is that the rate has already been gone down because of the cut of the custom duty, and second is that they are coming with the listed bonds, so they will be taxable based on that only, and that is now lucrating at 12.5% because after the 12 months, earlier if we buy the gold, so that is having a holding period more than that. So it's becoming a more lucrative and the more option for the government to collect the more money. Because
Correct.
now I will not make the investment in gold, definitely, because I am getting the 2.5% in the sovereign gold bond. I am getting the good rate now because of the reduction in the prices and it taking a tax deductive also for me.
But you will have to check your wife also.
I want to point one more anomaly.
Sir.
Why they have, they have discriminated on the basis of whether a financial instrument is listed or not. Like we see that the listed bond is getting a favorable tax treatment, and unlisted bond is treated as deemed short-term capital gain with respect to the period of holding. Same thing they have not done for the debt mutual fund. While the debt mutual funds are covered under 50AA, the debt ETF, like a Bharat bond, which is listed on stock exchange and traded actively, is also covered in 50AA. So why a synthetic taxation should not be given to a debt which is a productive asset, which is listed on a stock exchange, but more lucrative to gold and silver, which are unproductive assets. So this seems to be a big anomaly to my mind.
You are saying that is also listed basically.
I'm saying, yeah, the ETF, which exchange traded fund,
Right.
which is debt oriented, like a Bharat bond, is still covered in 50AA. Whereas a debenture which is listed is getting a better treatment. So why this distinction has not been made in case of debt oriented ETFs? That is the question in my mind.
Oh, actually, I don't have.
I think nobody has an answer.
Nobody
We'll
would have
probably have to
answer.
make a representation only. Yeah.
Correct, correct. And this may be either an anomaly or
anomaly, I can see. Yeah.
as a policy they may have done it.
Correct. Because 50AA was only for acquisition after Fund for 2020.
Exactly. So what were required before, while they have taken away the indexation benefit, which is a loss otherwise, but at least the tax rate they have brought it down from 20% to 12.5%.
They are saying they have brought it down to 12%.
Yeah. So just wanted to answer.
So-
I have a doubt here. This T50A investment, they are not taxable at 12.5%, but they will.
No, depending upon the holding period.
Yes.
So you will not have an indexation benefit. The calculation what people were doing was when they were transferring the old whatever this, so they were getting the benefit of indexation and they were being taxed at 20%. After indexation, there was hardly any capital gains. So therefore, the yield was much higher. Now you don't have the benefit of indexation, but you will have to pay 12.5% as tax. So the yield will go down. That's how someone was telling me the calculation
So
is.
I am just, looking at the rate schedule, this 12.5% rate is not covered.
No, 112 talks about 12.
So now, moving on to the next major change in capital gain is in respect of clause 3 of section 47. Now, clause 3 of section 47, deems a gift by anyone, corporate, individual or HUF, as not transferred. So, by virtue of this provision, all transaction or transfer by way of gift used to not get subjected to capital gain tax. Now, in the proposed, and courts have been taking view in favor of the taxpayer, applying clause 3 of section 47. And holding that such transactions would not be subjected to capital gain. Now, this clause 3 of section 47 is proposed to be amended, And this benefit of, from capital gain on gift would only be limited to individuals and HUF. So corporates and other entities or artificial judicial persons would not no longer claim benefit of this clause by transferring an asset by way of gift. So this is one significant amendment which may impact several of the reorganization which were in fact being contemplated in the corporate world, where shares etc. of one entity were being gifted to another entity without attracting capital gain incidence. So this is another significant
So,
change.
Neeraj ji, just to supplement, I think here the one of the major issue which will arise is how to effect the family settlements. Because sometimes what happens in case of family settlements, the shares are, as part of the family shares, are held in companies. So there have been instances where people, in order to give effect to the family settlement, the shares were being given by one company to another company. So I think this will affect. I think let's have Mr. Vora's comments also.
I think the view that was going around was that a company can be part of a family settlement. So if there is a settlement between members of a family and there is holding, let us say, interlock companies, or there are companies which have cross holdings. Now in that situation, in order to effect the family settlement, one view was that a company can be part of a family settlement. The shares of a company held by another company can be gifted to whoever is the intended beneficiary or intended holder without any tax incidence. Now with this amendment that is being brought about, I think there will be a challenge now to effecting family settlements and unlocking the cross holding between companies. Companies will be barred from making a gift of the shares to either an individual or to another company which is supposed to move to another group. So this will be, I think, a fallout of this amendment that is proposed.
So one of the big family settlements, one of the biggest in recent times, was a TVS group, announced I think 6-8 months back. You know how many group companies were involved? 70. Then 3-4 generations. It was, I'm told, I spoke to one of the advisors, there were some 15 advisors to this transaction. It apparently took them a few years to do this. Correct. 70 group companies involved.
No, you can't unlock without the flexibility of moving, shares of property from one entity to another entity. Now, if you were to move it for consideration, there will be tax, there will be stamp duty, there will be huge implication, which will make it unviable.
Actually, just to add to what Mr. Vora has said, when shares of one company are transferred to another company by way of gift, the cost of acquisition of those shares under the Act would be the cost of the previous owner. So, when these such transactions were undertaken in the course of these kind of reorganizations, there was no tax loss, because ultimately when the shares would be transferred by the transferee company or the donee, which is receiving those shares by way of a gift, it will pay capital gain on the full amount, starting from the it will be the cost of the previous owner would be taken as the cost, and then on the sales consideration, ultimate sales consideration, it will pay tax. So as such, as we see it, there is not much purpose being achieved by way of this amendment, and it is only obstructing these kind of reorganizations.
Secondly, conceptually also, if you see section 122 of the Transfer of Property Act, which talks about transfer without consideration, which effectively is nothing but gift, that nowhere talks about natural love and affection. So to say that gift can only be amongst the living persons is actually a misnomer. Secondly, if you see the Gift Tax Act, when the Gift Tax Act was there, gift tax was being levied on the company. So when you are giving an exemption under section 47, you make a distinction between company vis-a-vis living persons. But when you are taxing it under the Gift Tax Act or for any other purpose, there is no such distinction. So I think that way this theme of assuming that gift can only be amongst the relatives or amongst the living person is not correct. In fact, sir is also handling few of the transactions where gift, it was a transaction where the asset was transferred for commercial reasons. So it is not, and these issues can arise. So for example, a holding company, giving some subsidy to us, to its subsidiary, in order to help it out. So it's not necessary. That may be because of commercial reasons. So this will,
I
to
think
say
it will
that
be
for,
a great impediment in these.
As we speak, I think what is also coming to my mind, that with this exemption being taken away, you will have a double incidence of tax. The transferor will pay tax on capital
On-
gains, the recipient will pay tax under 56(2)(10).
Correct.
So you will have a double incidence in this.
Yes, yes. Now there is another amendment under section 50AA. There is change in the definition of a specified mutual fund. This is only a rationalization measure where a specified mutual fund was defined in clause 2 of the explanation of section 50AA to mean mean a mutual fund which invests more than 35% of the total proceeds in the shares of the domestic company. So this was leading to certain anomalies and difficulty. So now the definition is sought to be turned upside down. The now mutual fund, by whatever name called, which invests more than 65% of the total proceed in a debt or money market instrument, and a fund that invests 65% or more of the total proceed into unit or unit funds. So this amendment is proposed for rationalizing such transaction, because so this is then moving on to the next amendment. This amendment is again under section 50AA. So as we saw in the earlier slide, the unlisted bond and debenture now would categorically and specifically would be taxed as short-term capital gain, and there is no escape of playing around it. The courts in some cases have held to be capital gain. In some cases it was held to be the premium on redemption of bonds and debentures were held to be interest, in the nature of interest, and it was being taxed accordingly. So now it will be taxed as short-term capital gain, and it will come with it is coming with its own limitations and constraints, in as much as there would be issues as to set off of losses and capital loss and things like that as well. Now, cost of acquisition for offer for sale in case of an IPO. Now, in 2018, there was a complete shift in the taxation of long-term capital gain arising from transfer of equity shares. And then there was exemption under section 1038 was done away with, and it was sought to be taxed as per section 112A. Now and this was some kind of a concessional basis of taxing such capital gain, where there was a step up of cost available before for assets or shares which were acquired before 1st February 2018. So what was happening is that if the shares were acquired prior to 1st February 2018, the cost of acquisition was increased based on the indexation as on 1st of February 2018, or fair market value as on 1st February 2018. And there was certain condition attached for getting benefit of this provisions of section 112A, which was the sale of the listed share should be listed. Sale of the share which is happening, it should be a listed share. and STT should have been paid on such share. Now, cost of acquisition for such transaction for the purpose of section 112A was defined in clause AC of subsection 2 of section 55. Now, it is little convoluted definition of cost of acquisition, which says higher of the cost of acquisition of the asset, so actual cost or cost of acquisition of asset, and lower of FMV of the asset and actual consideration received or accruing on transfer. So lower of FMV or actual consideration and the cost of acquisition, whichever is higher was to be taken. Now for determining, you would notice cost of acquisition under this section or in the definition of formula which is given. FMV of the asset was one of the factors. So that was so the FMV was again defined in the explanation to the said section, and FMV. To determine the FMV, there are three things which are required. The shares, if the shares are listed as on 31st January 2008, and then if it is a unit, and share listed on, should be listed on the date of transfer. So in these situations, you could determine the FMV. Now, in case of offer for sale under an IPO, shares may have been acquired in the past, but when it is being transferred under the offer for sale, at that time, that point in time, it was not listed. So FMV one cannot determine, or one could not determine applying this section. Under this section, you can't really determine FMV for such share, because on the date of transfer, they are not listed. The view normally, or the position being taken by the taxpayer was that since the cost of acquisition itself is indeterminate or cannot be determined, applying the law laid down by the Supreme Court in BC Srinivasa Sethi or PNB Finance Limited, it was the position which was being taken or canvassed by the taxpayer is that the transaction itself is not taxable. The gain arising from such transfer was not taxable at all. Now, to do away with this kind of a position being taken by the taxpayer, the amendment is proposed to provide for a definition for cost of acquisition for such kind of transfer of shares in an offer for sale in an IPO, and the formula accordingly would be that cost of acquisition of such share which are acquired before 31st January 2018 would be increased by a multiplier, which is cost of inflation index for 2017 and 18 to the cost of inflation index when the shares were actually acquired. So what is happening is in this way, the cost of acquisition of the share is being grandfathered to 31st March 2018. So it is not, an intention was also like that, that they were not seeking to done away or do away with the taxation of this transaction at all. All that is being done or sought to be done is that the cost of acquisition or it is grandfathered as on 31st of January 2018. So up to that date, your tax incidence is being neutralized, and thereafter capital gain tax, whichever is happening, whatever capital gain is happening, that is being collected.
The larger question here is that if people have already sold in an offer for sale earlier and computed the cost basis the then provision of section 112, this is now a retrospective amendment.
Reassessment, sir. You essentially opened the door for reassessment. I was on Z Business when I read this, and offer for sale, we are journalists, so you look at offer for sale is where a lot of money has been made by promoters who have offloaded their shares, a part of their stake in companies during an IPO, and we've been flooded with IPOs in the last 6 years. So I'm assuming that the government feels, and the way to whatever I recollect on that day when the budget came and I read that provision, to me it almost seems like the way they worded it in the memorandum, if I recollect it, they are saying something like, this is how it was supposed to be,
Right.
and you all see, and these people have done it cleverly and gamed it, but we have caught you now.
Right.
So, as Mr. Vora rightly pointed out, this amendment is retrospective. So, there is one amendment in this budget, or significant amendment in this budget, and which would have ramification, large ramifications for taxpayers. This amendment is effective 1st April 2018. So, whatever transactions which have happened or which have passed in the interagnum, where people may have taken position that this such kind of transaction transfers are not taxable, and maybe the such position may have been backed by a legal opinion or something. This would give rise to dispute, open to reassessment, and may. Quickly. So, correct. Now, next important amendment is angel tax. I'll just quickly pose the important issue which arise here. So, angel tax, we all know, is valuation based taxation of share premium, or shares which are issued at premium, and if shares are issued at a premium higher than the fair market value, the same was supposed to be supposed to be taxed under section 56 to 7B, and there was disputes around the valuations. The taxpayers transaction or return would be supported by a valuation by in terms of the rule 11 UA or whatever, NAV or DCF, and assessing officer would invariably dispute such valuation and seek to substitute his own value, and this has given rise to huge number of disputes, particularly in the case of startups. In fact, in one report which came in 2019, almost 2,100 startups received notices for taxation of such kind of income. Now, this provision is sought to be done away with altogether. Section 56 to 7B would be omitted from the statute, and that is with effect from assessment year 2025-26. So while this section 56 to 7B gets omitted from assessment year 2025-26, the issue would remain or issue would arise as to what would happen to the past years. Now, one position which I could think of is, or one the taxpayer could possibly take is that since this provision itself is being obliterated and it is being omitted altogether, so this ceases to be on the statute. And you would recollect the judgment from the Karnataka High Court in the case of tax port, where applying the ratio of Kolhapur sugar mills case, the five-member constitution bench judgment, the Honorable Karnataka High Court held that since this provision, and in that case it was a specified case of a specified domestic transaction where section 40AI was excluded or omitted from the definition of a specified domestic transaction which were covered under transfer pricing. So they said that since the section itself got omitted and it is no longer in the statute, so that should not be reckoned with. It cannot be taken into account, and it cannot be applied even for the past years. Now, we may have views from Mr. Vora on this. How does he see this?
At least, personally speaking, I don't subscribe to that Karnataka view that just because the provision has been repealed, let us say in 2025, it never existed from 2012 to 2025. I think that better defense would be to say that the valuation cannot be tinkered by the assessing officer. You have a choice of valuation based on DCF or the NAV. And if you choose either of the two and there is a robust valuation, I think unless the assessing officer is able to point out glaring errors in the valuation, this can't be interfered.
So this is Delhi High Court judgment which we are showing on the screen. There are two judgments from Delhi High Court and many judgments from other High Court.
And I think what also needs to be kept in mind, this was brought in as a measure to tax what the department could not figure out under Section 68. They said companies were receiving share subscription at substantial premium, and the source was explained that it came from another company, it came from another person, and they paid the premium. So in order to plug that loophole, the department couldn't do no better, so they brought in this Section 5627B. And there are tribunal judgments which have said that if it is a bona fide transaction, if the investor is around and it's a transaction which has been implemented according to the Companies Act, there is no reason why it could be taxed as income under Section 5627B. It is otherwise a capital receipt, and this deeming provision seeks to deem this as income. So the deeming provision needs to be strictly construed. There are judgments of the tribunals which take this view independent of the valuation issue. So I think that's a better defense.
Can I try to position this on behalf of taxpayer against your interest possibly? But I'm just wondering, sir, the fact that the section itself has been done away with, even albeit prospectively, shouldn't it weigh in the minds of the courts that it's been done away with, so it was illogical to begin with, which is why it's been done away with? Won't it help you in past litigations?
No. I think that will be a ground to say this. But to say that this was not applicable from 2012 to 2025, I am not subscribing to that view. This is certainly a good defense to say that the legislature has consciously omitted this provision.
Actually, this argument was even addressed in the Manmohan Kohli's judgment, and Delhi High Court was pleased to give a positive view on this argument. The decisions like Jile Singh's case and Kolhapur Sugar Mill, and these are all supporting that if provision is omitted without a saving of for the earlier period or something, then it has to be.
No, I would think it is omitted before it became effective. Then in that situation you can say that it never existed. I think we'll leave that for the time.
I think the larger point which Arun sir made was, what is the intent? The intent always, if the section has been deleted now, whether it should be applied to the earlier years or not, I don't know whether any clarification will come or not, but I read on the Economic Times, it was reported in the first page, that Finance Minister probably made a statement that since now we have done away with 5627B, the past litigation cannot go on just like that. What she actually meant was not clear. Probably they might come out with some clarification or something. But the intent seems to be that the litigation on this issue in the earlier years should somehow be resolved. How it will get resolved is something to be seen.
And so as I understand, this Karnataka High Court judgment in his tax court is before the Supreme Court is pending.
I think while this section is amended, this does not take away the onus of the company under Section 68 to explain all the three ingredients: identity of the subscriber, genuineness of the transaction, and creditworthiness of the subscriber. So that onus will still remain.
Yes, assessing officer can still invoke provisions of section 68 and examine this transaction. So this is still open. This door is open for the assessing.
First April 2025, so all the transactions for the current financial year will still hold 60 years after.
No, this is assessment year 25-26.
Now, equalization levy, quickly pointing out, equalization levy on 2% equalization levy on e-commerce supply and services, that also has been done away with, and curiously actually this levy was brought in the interregnum till two-pillar solutions were actually put in place. Now, India has not yet put in place two-pillar solution in the statute, regime in its statute, and one would, feel as to why and how the government has suddenly repealed made this e-commerce supply transaction of e-commerce supply and services not subject to equalization levy. So all these businesses would no longer have to be paying tax by way of equalization levy in India. The budget, the memorandum frankly says that this levy as such was ambiguous and as a result leads to complex compliance burden. That's the ostensible or stated reason for removal of this levy. Frankly speaking, the equalization levy which was being collected by the government was to the tune of 3,900 crore in financial year 2022. It came down to 3,825 or 27 crore in the next year 2023, and then in 2024 it came down to 3,500 and odd crore. So the collection on this levy was going down. The government says there was a compliance burden, cost of compliance so far as this levy is concerned was more. However, importantly what was happening is that when this equalization levy was introduced, the US government in fact resisted, and there was certain amount of retaliation from the US government, and they were seeking to seeking to levy 25% levy on the products which are being imported from or exported from India to US, which was in a transitional arrangement with the US government. The due date or validity of that transitional arrangement was till 30th of June 2024. So maybe under that, that may be the trigger for the government to do away with this levy on e-commerce transaction. While pillar,
all of this is correct. The levy, according to me, was clearly ambiguous. There is no provision provided in the Finance Act of 2016 as amended in 2020, amended 21, of the mechanism for collection, assessment, refund. And many companies were sitting on the fence not paying the equalization levy on the basis that if they are tomorrow held liable, they would only have to pay interest. And we had written a lot of opinions that penalty would not be leviable. So clearly this was one trigger. The second was the pressure from the international community. The US had clearly retaliated because the companies like Netflix, Google, Amazon, who are paying the equalization levy, don't get a credit for this tax in the home country. And India, nobody is clear whether this is income tax or this is indirect tax. This was levied, if you recall, through Chapter 8 of the Finance Act of 2016. So whether this was constitutionally valid, whether this could be treated as a direct tax or it could be treated as an indirect impost, there was actually no clarity. And so I think it's good it's been done away with.
Correct. Even intercompany transaction of import of components, etc. from the overseas group company, that was getting attracted for such levy, which may not have been the intention.
Since Ajay ji mentioned Google, I'll just take 5 seconds. Google's cash reserves are more than India's corporate tax collections. Over $140 billion. So whenever we say economic superpower, $5 trillion economy, one company in the US, their cash reserves is more than India's corporate tax collections.
Neeraj, we can skip this.
Yeah, so IFSC we are skipping because I don't think
it's there in it's there in the handout anyway.
Correct. And then anti-avoidance and buyback.
I think this is important, actually.
Yeah, so we'll deal with the buyback of shares. So, there is a complete sea change in this regime of taxation of buyback of shares. So, I will just quickly explain the change which is proposed in the finance budget. Earlier, the transaction of buyback was taxable or not taxable in the hands of the recipient shareholder, and the tax on this transaction was being paid by the company which is buying back its own share, and in terms of section 115 QA. So difference between the cost and the price which the company paid, cost of purchase of shares and price which the company paid to the shareholder. For buying back the share, the company used to pay 20% tax under section 115 QA, and this amount received on buyback was not taxable in the hands of the shareholder in terms of section 1034. Now, there is a shift in the basis or manner of taxation of this income. This income now would be taxable in the hands of the shareholder as dividend. So what is being supposed to be taxed or proposed to be taxed in the hands of the shareholder is the total consideration which is being paid or received by the shareholder pursuant to the buyback or for the buyback as dividend. That will be taxed as dividend. So if rupees 100 is paid for purchase of the share, so entire 100 rupees would be taxed as dividend in terms of section 222 clause F, which is being proposed to be incorporated in this budget. And then the cost of acquisition, the corresponding adjustment or consequential amendment is proposed in section 57, whereby cost of the shareholder would not be able to claim deduction for the cost of acquisition, which is the cost incurred for earning such income. So that would not be allowed as deduction in terms of section 57. And this cost of acquisition, which is incurred on acquiring the share by the shareholder, its value would be deemed to be nil. So there is a corresponding, there is an amendment being proposed or proviso being inserted in section 46A, whereby value of such share is treated as nil. So what would happen effectively is the cost of acquisition which is in the hands of the shareholder, or the cost of acquisition which he has incurred, that will on this buyback or pursuant to this transfer by way of buyback would give rise to a loss, because value of the shares would be treated as nil. There would be a cost of acquisition of whatever, say 100. So when the shares are bought back, there will be a capital loss of 100 in the hands of the shareholder, which will be available for set off under section 74. So this is how this mechanics. What would happen is that it'll be set off. It'll be capital loss and in terms of section 45, and it will be long term or short term depending upon period of holding, and then it will be accordingly set off. If it is short term, it will be set off only against. It can be set off against capital gain. If it is long term, then it can only be set off. The loss can only be set off against long term in terms of section 70. So this is how we have explained this by way of an example. I think it's a simple illustration which I need not.
So on this buyback, I think I just wanted to make a few comments, and I think Arun will remember this. First, when the buyback provisions were introduced, you had a buyback. It just said buyback under section 77A of the Companies Act of 1956. And that was not treated as dividend by virtue of a specific amendment in section 222. from 1/6/2013, law was amended to say that a buyback under any law would be covered under that particular section, I think 112, would be covered under that section. Now this assessee, and I think you are aware of this, Cognizant,
Yes.
did a buyback before the amendment of 1/6/2013 became effective. And that buyback was under sections 391 to 394 of the Companies Act of 1956. That was sanctioned by the Madras High Court. And the shareholders reported capital gain. There were some shareholders from Mauritius who claimed the exemption under the treaty. The tax department picked this up, and the tax department said, no, we are not accepting this as capital gains or capital gains in the hands of the shareholder under 46A. We will treat this as dividend under section 222, and huge tax was imposed. I fought and I lost, unfortunately, in the tribunal. You reported that 19,000 crores.
Yes.
19,000 crores was the tax on that Cognizant under that scheme, and that was argued in the Madras High Court. Unfortunately, I think it has got released because the judge got elevated to the Supreme Court. So that matter has got released. It is still pending in the court. So this is now the state of buyback. Now this is moved from buyback now directly into dividend. And dividend, as Neeraj pointed out, on the gross amount of the dividend, you will allow the cost of acquisition as a capital loss. And I think people will only be encouraged to book some fictitious capital gain in order to offset the capital loss. I really can't understand the logic of treating the gross amount as dividend and treating the cost of acquisition as a capital loss to be set off in the future.
Yeah.
So this,
I can claim credit. I broke this news to the world on national television because सबसे पहले उसी पे I was just scrolling and I said buyback and I read it twice. I thought that it's 20 years since I have written my CA final. कुछ तो मुझसे गलती हो गया होगा पढ़ने में. Luckily in the memorandum they had given an example. Example दिया था. मैंने सिर्फ ऊपर देखा, नीचे देखा, वापस ऊपर देखा कि वो मैच हो रहा है ना. I said fine. And I was like क्या हो रहा है? And then I went back to the title and they said that deepening of tax base and anti-avoidance. It's come under that. It just shows to you how the government is thinking.
no, but currently I think the provisions as they stood, you see the provisions as they stood were being used or misused because the computation of the buyback amount in the hands of the company was on the basis of the rule 40, if I 40 or 44, if I correctly remember. Now we are three people who have offered our shares for buyback, right? Now buyback is open to all the class of shareholders. Only three of us have opted. Now what is being looked at is the shares that have come. You bought it in 97, I bought it in 2000, he bought it in 2003. So they have to trace that what was the issue price in 97, in 2000, in 2003. You may have acquired it for whatever value. So if it was a 10 rupee share which is being bought back at 12, the tax was only on 2 rupees. So therefore, and there were challenges of if there are many people who have given their share for a buyback because the buyback can only be 25%. So you have shares from different shareholders. Now how do you appropriate the issue price? Shares have been sold, have been issued at different points of time.
Yeah,
So
I'll be honest, sir, this is a discovery for me.
No, so
I
therefore
thought
this
that whatever is the buyback amount,
No.
that the company does, जितना shareholder को पैसा जा रहा है buyback में, I thought 20% of that.
No, minus the cost. So
Minus issue price. Basically.
minus the issue price. So minus the issue price. So that's how it was being worked, and there were challenges on how you worked. I have written several opinions on how the company would, allocate when they receive shares from a class of shareholders who have bought it at different points of time.
Yeah.
So I think this is intended to plug that thing where large amounts were being paid out as buyback without tax being recovered or not being recovered at the substantial value. I think that's the purpose. One question, and you can probably answer whether redemption of preference shares would amount to buyback.
No, sir, that's the open question as of now. That is what we have noted.
No, Ajay ji is reserving it for his opinion. मैं अभी सोच रहा था उन्होंने इतनी बार opinions को refer किया है. I need to be friends with Rohit, Neeraj and some of Ajay ji's juniors. Opinions मेरे हाथ लग जाए तो it will be good for tax sutra.
This is what is called a silent way of marketing. Which Mr. Vora is indulging into.
But second point is inconsistency. Yeah? You look at, someone told me yesterday that every 8 years, the government has changed its dividend taxation policy in the last 3 decades, every 8 years. What is the second rationale given for this? The rationale given in the memorandum for the buyback amendment is that we want to bring it on parity with dividend taxation.
No, I'll just show to you how is it impacting. You see on the screen, you'll see I am not giving detail of the or numbers or the illustration. In this illustration, in the old or existing regime, the tax incidence on the taxpayer would work out to 2,000 rupees. Now, in the new situation or in the post-amendment regime, he'll have to be paying tax on the same very transaction of now 9,000 rupees. Of course, he'll get a capital loss, on account of that cost of acquisition of 20,000 rupees. So maybe if it were to be giving a tax advantage of 12 at the rate of 12.5%, so it will be about 2,500 rupees. So net, he has to pay tax of about 6,500. So this is the difference. From 2,000, the tax incidence would increase to 6,500.
But sir, I have a question like there are two type of the investor. One is the owner of the company, and second is the individual investor who are the very small shares. Okay. For those company having a ownership of the company the shareholder, so it is okay that they are shifting it from the 23% of capital gain tax to now the dividend equivalent to the dividend tax. Okay. But for the individual investor, if I am giving a share of TCS at the rate of 4,500, okay, so I have gone for the shares also. Now I will pay the if we have a dividend tax. Suppose I am this slab of 30%, but now the capital loss will be adjusted which I have applied. That will be 12.5%. Because that is not a similarity, because it should be either should be allowed against the adjustment of by 30% taxable income. Because that's a
Essentially they are saying that buyback mein tender mat karo. They are saying wait for the stock price to catch up to the buyback and then it sell it on stock exchange.
it will automatically reduce the buybacks.
Buyback is practically killed by
Yeah, that's true.
Correct.
That's true. Sir, can this be challenged constitutional validity on characterization?
I doubt very. I doubt.
The characterization is illogical, sir. There is no logic whatsoever.
No, if you look at the different limbs of section 222, I think monies that are paid back to the shareholder are normally taxed under one.
No,
or the
you are
other clause.
admitting this is extinguishment. The memorandum says this is extinguishment.
Yeah, correct.
How can you say that in extinguishment I will tax it as dividend?
No, because you see, if you look at 222, you pay out monies on liquidation. Your shares are extinguished; they are treated as deemed dividend. You pay out monies on reduction of capital; it is treated as deemed dividend. So I don't think you will have much success in a court challenging the constitutional validity.
in that case, it is only to the extent of reserve.
Correct. Yes, better to sell in the market.
So
I think one issue, Neeraj, on this buyback will be in the hands of the foreign shareholder. Whether this will be treated as under the head capital gains or this will be treated as dividend, because under the domestic law it is deemed as dividend. So the challenge will come if the capital gains in the hands of the foreign investor are exempt from tax under the applicable treaty. Now can he then claim that since this is actually an extinguishment, as you said, this is transfer in law, so therefore this should be treated under the head capital gains, and if it is exempt, so be it. So it can't be taxed under the deeming fiction under the Indian law. The act must be overridden by the treaty. These are issues that will arise.
So, friends, actually it is about 12:15. So if
Take a 10-minute break, tea, coffee break, or do we want to do it non-stop? Let's take a break. A 10-minute break.
ये स्क्रीन में क्यों नहीं आ रहा है?
I think आपने शुरू कर दिया ना रोहित, फटाफट आ
Yeah.
जाएंगे लोग. Hello. Can I request everyone to please come in? You all can carry your coffee, tea inside. Yeah, we are starting with an important provision.
So good afternoon everyone. In fact, we have a lot of ground to cover. So what we will do is we'll concentrate on three major changes which have happened in this finance bill, which are proposed to be. One is the reassessment regime. Second is the search assessments, which now will be block assessments. And third will be Vivad Se Vishwas scheme 2024 in its new avatar. And then I'll very quickly refer to the other provisions also, but mainly I'll concentrate on these three aspects. Now coming back to reassessment regime, now before I take you to the provisions, as we all know, reassessment regime was completely overhauled in 2021. From 1/4/2021, a new reassessment regime came in, wherein the search assessments and the reassessment which were in its earlier avatar were consolidated together and a new scheme was built in. Basically, from 1/4/2021, the scheme was that the principles of GK and drive shaft, which said that reasons have to be given, then you can file your objections, objections have to be disposed of by way of a separate speaking order. They were all codified in the form of a section called 148 capital A. And then this reassessment notice was to follow the 148A process. So that was broadly the theme and the substance of the new reassessment regime. And that also included the search assessments, because earlier the search assessments used to take place under section 153C and 153A. And I'll touch upon those those provisions also while we'll go along. Now what is now proposed in this finance bill is that a new reassessment regime will be there. So when Mr. Vora said earlier pre-amended regime, amended regime, new regime, and then this will be a newer regime. So this is, and surprisingly 2021 the amendment made, now we are in 2024. So this is little, this gives them some kind of an uncertainty as to why, a scheme is bringing in a scheme in 2021 and say that this is a new scheme with a new version, and then again you do away with the earlier scheme and come with a new scheme. This appears to be some kind of a confused state of affairs, but and what we will see when we'll go through the the fine prints, we will find that what basically the intent seems to be is to dilute the legal precedents which are coming, and the tighten the or give more and more powers to the assessing officer. With this brief background, what I'll first do is I'll refer to the provisions as proposed to be amended, and then analyze those provisions as to what are the questions or the issues which will arise. So this is the slide which is you can see is basically the proposal which are introduced. Now 2021 this scheme was introduced, as I pointed out. This required the procedure to be followed in terms of section 148A, and then the order is to be passed. Now the third bullet says that this new reassessment regime is sought to be brought with effect from 1st September 2024. So prior to 1st September 2024, we will be governed by the present regime, which is this 2020 reassessment regime. From 1/9/2024, we will be governed by the new regime, which is proposed to be introduced now. Now the stated aim of this is new reassessment regime is 2024 is to rationalize the existing reassessment regime and provide the ease of doing business. This was the exact rationale which was given in the 2021 scheme also. So that was supposed to be rationalizing the scheme. Now this is supposed to be rationalizing the rationalized scheme. So this is the logic which has been given. Now what are the changes we will now deal with? As I said that 148A presently has 4 clauses, 148A, A, B, C and D. 148A says notice has to be given. 148A says that the inquiry has to be done. B says the notice has to be given to the assessee to calling for its explanation. C says consider the reply, and D says passing of an order under 148AD. Now the key changes which are proposed in this finance bill is that the return of income. So there are two now regime, 148 notice, they have given separate time limitation, and 148 capital A, process, they have given separate limitation. Now, this is, we have tabulated it, the difference. The applicability, first is the existing regime is applicable till 31st 8 2024, the new regime from 1/9/2024. So, notices which are issued on or after 1/9/2024 will be governed by the new regime. Now, the time limit to file ITR, presently it is, now they are proposed that it will be within 3 months as may be allowed by the assessing officer. This is little ambiguous, because if you see the existing provision, it says that the notice will not give you less than 3 months. So 3 months was given. Now it says whatever time is specified in the notice, you have to file your return of income. Now AO can give you 10 days also to file your return of income, because it is within 3 months. So this is an ambiguity which is there in the existing finance, the proposal. Now the requirement of approval. The requirement of present, this, if you see the present scheme, there are requirement of approvals at every stage. For example, an inquiry is to be made 148AA, then 148AB, etc. And the approval presently is required from Principal Commissioner and Principal Chief Commissioner. Now, the 151 is also sought to be amended, and Principal Commissioner and Chief Commissioner are no longer involved. It is now with the Joint Commissioner and Additional Commissioner. So the approvals are, all actions do not require an approval. Secondly, the hierarchy of the officers who are now the approving officers have been brought down from Principal Commissioner to and Principal Chief Commissioner to Joint Commissioner and Additional Commissioner. Probably they are more busier, so therefore they are giving more authority to the lower, officers to give them the approval. Otherwise, there seems to be no logic why earlier approving authority, and the logic given was that why we are giving powers to Principal Commissioner and Principal Chief Commissioner is that they are high ranking officers. They are supposed to apply their mind before permitting the assessing officer to issue notice. And that is why we want higher ranking officer, and they were said to be an inbuilt checks and balances. Now, what is the message being sent? That those officers are not now approving, it will be now be Joint Commissioner and Additional Commissioner. So these are broadly our comments, that earlier there were non-compliances which led to all this, the lot of litigation. With the new regime also, we don't see the litigation going down. And the new section gives a maximum period of 3 months to file a return without any power of extension. Now the amendment to the procedure of 148A. Now the key changes I have pointed out. One is, present scheme specifically says 148A says that the assessing officer can conduct an inquiry before issuing you a 148AB notice. Now that concept of inquiry has been done away with. Now he can issue you a notice under 148A1. But the good part which they have inserted over here is that 148A1 notice is mandatorily required to be accompanied with the information on the basis of which the notice is sought to be issued. Earlier in the existing regime, that was an implied requirement, and as was laid down in Ashish Agarwal also, that if you are issuing a notice asking for a reply to the assessee, you must confront him with all the information which you have, basis which you have issued the notice. That was an implied requirement. Now that has been statutorily incorporated into this section itself by saying that when you issue the notice, you have to issue the notice along with the information on the basis of which you propose to start the proceedings. So that is what I have mentioned in this specific obligation to give the information. Another important amendment which has been made when we compare the existing provision and the new provision, because substantively it more or less it is same, but there are few major changes which I have done. Present section says 148AA talks about inquiry, B talks about notice being issued, 148A small c talks about consideration of my reply, and 148AD talks about order being passed after taking care of all the material which is available with the assessing officer. Now what is important is C has been deleted, so the requirement of consideration of reply has been done away with. At least I was not able to understand the logic of deletion of clause C, which specifically required the assessing officer to consider the reply, because that's something inherent, because that's principles of natural justice. I file by reply, AO is supposed to consider. I think this word consider, Mr. Vora, I think you argued, it has been interpreted by the courts as to what exactly it means.
But why do you think this has been removed? Because if you look at 148A3, the order has to be passed under 148A3. The assessing officer shall, on the basis of material available on record and taking into account the reply of the assessee. This is there.
This was exactly the wordings in D also. But C still they have deleted. If we compare with D, D exactly was same wording, but C was also there. We talked about consider. Now the difference in the language is D does not talk about consideration.
I think taking into account the reply.
So therefore there is an there was no reason to delete clause C. My only point was there was no reason to delete clause C because clause C talks about consideration of the reply and which is inherent, which has to be done because once I file my reply it has to be considered. Now the order, presently the order there is a specific requirement of 148A(d) that the order must be passed within 30 days of my filing of the reply. In the new regime, in the proposed regime, there is no requirement. The logic probably appears to be when I will take you to the section 149 is that now there are two time limits. One for issuance of 148A notice, second for issuance of a 148 notice. And that there is a gap of 3 months between the two. So the assessing officer is required to complete the entire process of 148A within those 3 months. And that is why an extended period of 3 months is given for him to issue the notice under section 148. But there is present scheme talks about him disposing of your order, passing of an order under 148A(d) within 30 days. Now there is no statutory mandate, that has been done away with. So these are basically our broad comments. I dealt with this, that basically the requirement of consideration has been done away with. What is the impact of that? I think that time will tell, but according to us, there was no reason to delete clause C. Second issue which normally comes up in the context of 148A proceedings is whether a hearing, a personal hearing is required or not, whether the assessing officer is required to give you a personal hearing or not. This has been subject matter of litigation and the courts are also divided on this aspect because some courts are taking a view that personal, in fact, we have in some of our writ petitions, we have gotten orders where the court directed the assessing officer to pass an order under 148A after giving the personal hearing to the assessee. But there are instances where the court has been taking the view that for 148A order to be passed, a personal hearing is not a mandate. So he can give you a personal hearing, but there is no statutory mandate for him to give you a personal hearing. So that's one of the issue which we highlighted. Now, the 148A notice, one important aspect is 148A notice can be issued only if there is an information. Now, information, there are 4 or 5 clauses which are defined as to what could constitute information. One is risk management, information through risk management strategy, audit objection, information in the form of an order of a court, etc., etc. In this context, normally, what the controversy which arises is what is the nature of the information, whether any information which is flagged can be the cause or the reason for the assessing officer to start a 148A process. So that the view which is preponderance of view is that the information must result in an escapement, because ultimately why you are starting a 148A process is for determination of your escaped income. So therefore, just because some information comes, that cannot simpliciter be a trigger point to start a 148A process. Second, normally the issue arises is change of opinion. As we all know, we all go through regular assessments, and in regular assessments, most of the issues are examined. At times, when the assessing officer is satisfied, he does not, pass a speaking order on that particular issue on which he is satisfied. So generally, based on looking at the assessment order, one will not be able to find out whether a particular issue has been examined or not. So the issue which normally comes on that particular issue, if the information comes, whether the assessing officer can restart the proceedings, reinitiate the process, which we normally call it as a change of opinion. Again, the house is divided, but generally the view is that change of opinion cannot be the ground to restart the proceeding. If an issue is already examined, that cannot be, the reason to restart the proceedings. Now, the other changes, as I pointed out, was the time limit, section 149. If we see present section 149, there are 2 time limits. One is within 3 years, second is within 6 years, extended period of 6 years. Now, the time limit is sought to be reduced from in the second block. So first limit now is 3 years, and the second limit now is sought to be brought down from 6 years to 5 years. 10 years is because of the search assessments. Existing provisions talks about 10 years because that was because the search provision was also incorporated as part of 147 process. But otherwise reassessment was supposed to be up to 6 years, and there was a grandfathering provision also till 2021-22. Now the 6-year limit is sought to be reduced to 5 years and 3 months. That's a welcome change which has been done. Now, as I pointed out, there are two limitations which are there. One is 148A notice limitation, which is 3 years, within 3 years and 5 years. And 148 notice will be 3 years and 3 months and 5 years and 3 months. So those 3 months the assessing officer will take to go through the process of 148A. That's an inbuilt or an inherent requirement, because otherwise the orders will be barred by limitation. So this is a comparison which we have done as to the limitation provision. What is also important over here is the tinkering in the language. If we see the language of sections, that has been tinkered, the requirement. So within 3 years the assessing officer can reopen, there is no bar. He only has to have information, and he has to be satisfied that there is an escapement of income which is likely to be there. Beyond 3 years, the existing requirement is, as we have this given a comparison, that beyond 3 years, up to 6 years or 10 years as may be applicable in one present provision, he can reopen the proceedings provided the escapement is more than 50 lakhs and the assessing officer has in his possession books of accounts, material, documents, etc., which show escapement reflected in the form of an asset or expenditure, etc. Now kindly see the difference in the language which they have done. The present says, the proposed amendment is evidence related to any asset. Present provision says evidence of escapement of income in the form of an asset. Now it says related to an asset or an expenditure. So that just to explain the difference with the help of an example, supposingly I have an house property. Earlier the reopening can be done if there was escapement on account of house property. Now the information can be house property plus rental income. So the information is related to an asset. Related word, the courts have construed, is a much wider word as compared to other words. So related means anything related to an asset, any information related to an asset which comes to the notice of the assessing officer can now be a trigger point for the purpose of reopening. This is a little wider in that sense, much wider powers being given to the officers to reopen the proceeding. And the threshold is only 50 lakhs. 50 lakhs may appear to be big, but in present terms, in most of the corporate, 50 lakh is not a very big sum. In big corporates who may be filing returns of more than 100 crores, 10 crores, 50 crores, 50 lakh is not a very big sum. So there is an uncertainty which continues till 5 years in all those big cases, because 50 lakhs is usually a threshold which can easily be crossed. And that scope has been widened and much wider powers has been given. So this is a very important change which has happened. On the face of it, it may look to be the same provision. But if we minutely examine the difference in the language of the earlier provision and the new language, there is a substantial difference in the language. And this is the period of limitation, which is the last table. One important aspect is, which we will notice is, since presently 6 years reopening can be done, so 2018-19 reopening can happen till March 2025. So you can receive a notice for 2018-19 up to 31st of August 2024. But once 1st September 2024 kicks in, 2018-19 will be barred by limitation, because now the limitation is 5 years. So 18-19, 5 years would have expired in 2024, and therefore 18-19 would be barred, and the proposed section will be applicable for assessment year 2019-20 onwards, not for earlier years.
One point, I think you mentioning about the 6 years, but the 6 could be extended to 10.
No, now it is not.
No. In the earlier regime, 6 could be extended to 10, but this is very welcome, because to this extent.
So these are the grandfathered years.
So
18, 19 and 19, 19, 20 were in any case grandfathered years, so 6 years limitation was only.
so under the old law, if you had an
If a
evidence,
search, in a case of a search, this could have been.
or even otherwise, if you have evidence that suggests,
No, then these were grandfather, 18, 19 and 19, 20.
no,
because of
that
6
you are
years.
saying the 6 years,
Yes.
overall limit of 6 years, otherwise it could go up to 10 years.
Up to 10.
This has now
So
come
under
down
the
to
new
5.
regime, 18, 19 will become time barred on 31st of August 2024.
No, 18, 19 is already time barred on 31st March 24, no? 4 years.
6 years will be 25.
No, 6 years will be 25. So therefore they have removed the proviso, the 149(1)(b).
Yes.
That under the limitation under 4 years and 6 years, that has been taken away. That is not
Yes.
there in the present
No, no.
situation. So this 5 years will now go up to
18, 19 will become time barred. 19, 20 will be up to March
18,
2025.
19 will become time barred, March 20,
Yes.
24.
Now, these are some of our observations. So first, of course, the reduction of time limit for 10 to 5 years is a laudable, the amendment. 18, 19 will become time barred, as I just pointed out. Now, an interesting issue, what will happen to a 2018-19 set-aside cases by the High Court? I think they will still be governed by the old law. There is nothing much. And the last bullet which we pointed out is the widening of the scope from represented in the form of an asset to related to an asset. Now, these are the sanctioning authority which I was just pointing out. The sanctioning authority presently are principal commissioner up to 3 years, and beyond 3 years is principal chief commissioner or principal director general. Now the amendment which is there is, now the proposal, the approving authority will be additional commissioner and additional director of income tax or joint direct commissioner of income tax. So no longer the higher rank officers are involved in this process. One point which I just missed out, in fact that seems to be a lacuna in section 149. If you see the existing section 149, because 149 now says 3 years 3 months and 5 years 3 months. Existing section says 3 years and 6 years and 10 years depending upon which year it is, plus the period during which there is a stay operating, that gets excluded, that gets extended. Now that provision is not there in the existing section 149. So supposingly you get a notice and you challenge it in the High Court and the High Court grants you a stay, and by the time the stay gets vacated, these 5 years gets over, probably they will be barred by limitation. So that's a lacuna. I don't know whether they will cover up in the final round, but as of now, they have missed out this provision to be inserted. I'll come to that, sir. This is the next slide. So this is 151. So any comments are on this, that they have reduced the hierarchy of the officers?
I think you are also aware of the many writs that have been filed in the court dealing with the approving authority, whether it should have been the principal commissioner or the principal chief commissioner, and the court struck down the reassessment where the approving authority beyond 3 years was the principal chief commissioner, but approval was given by the principal commissioner. So the court quashed all those proceedings. But I still see no reason why there should have been a dilution of the authority. Of course, we have seen in practice there was hardly any application of mind by the approving authority. They would just say approved, or I find enough justification in the reasons given. So I don't know what's the reason for this delegation to a lower level, but this will possibly, I think, increase the number of 148 notices that are being issued without their receiving the approval of a superior authority who is expected to apply mind before the notice is issued. But I think that's how they have projected it.
So let me move to the next aspect, is the block assessment regime. Before I deal with the specific provision, I just want to show you one slide wherein we have done the comparison as to how.
Just one comment, Rohit, that we were talking, we started this entire budget conference with a confused state of mind. If anything reflects a confused state of mind is changes to reassessment. Does anyone here remember when did reassessment come into the act? Anyone remembers?
Or is that there from the 1922 Act?
89, sir. The current reassessment regime as it.
Current, yeah. Otherwise
89.
No, it's been always there.
I think as it's, I think 89 में फिर substantive हुआ होगा change कुछ. Around, that's when I recollect because I did attend one.
No, this is there from 1922 Act. You
No,
are
but
good
major
students,
changes
Section
were happened
34.
in 89.
89, right?
yeah.
So now just imagine, we did a presentation 4 years back, and that was done by someone who's been against Sir for last 5-6 years, Zoeb. A beautiful presentation on reassessment. 4 years back, and if you look at what's happened in the last 4 years, it's like a reassessment has taken a life cycle of its own. The litigations take a life cycle of their own. Some of the provisions of income tax then have a life cycle of their own, and reassessment is one of them. If you want to do something radical, you would think that reassessment should go. Some of these chapters should go, because as Sir said, pre-21, post-21, you have Ashish Agarwal in between, Tola in between. These are litigations which are not going to see the end of the day. No sunlight whatsoever. They say that finally there is some light at the end of the tunnel. This is the endless tunnel or a bottomless pit as you call it. But reassessment reflects everything that is broken in the Income Tax Act.
On a lighter side, Arun, we have a judgment from the Delhi High Court titled as Twilight. and when I often argue, I tell the judge, I have come before you in complete sunshine.
Yeah, but to sum up, a reassessment reflects everything that is broken in the Income Tax Act. Completely broken. And which is why if people say that I will change something, some wordings here and there in this act and things will get better, it's not going to happen.
I thought this comment will come after seeing the block assessment. So you will have a more comment. So I'll just show this slide which we have prepared is how the regime has moved. So for example, the surge date, the left hand side is the surge date. Pre-1995 it was all reassessment. Normal 148 notices used to receive in case of surge. From 1995 to 2003 we had this concept of block assessment, which is now again being introduced in 2024. From 2003 to 2021, 31st March 2021, we had a regime called 153A and 153C. Now from 2021, they merged it with the reassessment regime. So from 1/4/2021 to 31st August 2024, you have this 147 regime. Now again we are going back to the block assessment regime, which is from 1/9/2024. So one will have to remember all these dates as to how we have moved from one regime to another. Now coming to the provisions are the way it is been drafted. I think there is lot of homework which should have been done before what they are the theme. I'll first explain the concept which they are trying to build into this new block assessment, how it is different from the old block assessment and how they confuse these two concepts over here. So earlier when the block assessment was introduced, as I pointed out way back in 1995, the concept was there were two parallel assessments. One was normal assessment and the second was block assessment. Block assessment was only for search matters and normal assessment was your routine regular assessment. Block assessment was strictly on the basis of material found during the course of search. In fact, lot of controversy went into whether the assessment addition has been made on the basis of material found during course of search, non-search, etc., etc. So the block assessment was a parallel assessment wherein the addition was to be restricted to material found during the course of search. So there were two separate assessments. When they moved to the regime of 153A, 153C, the concept of abatement of proceedings was introduced. So the concept of search abatement was that if the search takes place and if any regular assessment is pending on the date of search, then that proceedings will abate and will merge into the search assessment. So this was the concept of 153A and 153C. Now what they are seeking to do, what the finance bill is seeking to do is merge the two things. The block assessment, now there will be no parallel assessment, and 153A and 153C concept. So therefore now there will be, in case there is a search which takes place, it will be only one assessment which will be block assessment. The pending assessments will abate and everything will be brought into a block assessment. which will be subjected to tax at a much higher rate of 60%. And then I will show you the absurdities which it will result as a result of calculation of your income. Now let us see what are the provisions which have been introduced, and then I will show with reference to specific examples that how this has not been properly drafted. So first of all, the concept of block period. Earlier the concept of block period was that if the search takes place in the middle of the year, the search year plus preceding 10 years were treated as part of one block. So there were 11 years which were treated as part of block period. Now the concept has been little bit tinkered with. The block period now has 6 years, so 10 years has been reduced to 6 years. So the block period will have 6 preceding years prior to the year of search, plus the search year, and also the year till the time these search proceedings are concluded. So just to give an example, supposedly the search starts at December 2024. So the search year will be 24-25, which will get covered as part of block period. Supposingly the search concludes in December 2025, not in 2024. So in that situation, even your 25-26 will also be treated as part of block period. So there will be 6 plus 2 years. If the search gets concluded within the same years, it will be 6 plus 1 year. So that is one change which they have done with reference to the block period. Now the concept of abatement, which was not there in earlier block assessment, has been introduced, which has been picked up from the 153A concept. Now here a major flaw has happened. The major flaw which has happened is the provision says proceedings pending on the date of initiation of search will abate. And this concept is equally relevant both for search cases as well as non-search cases. And I will show you the absurdities in case of non-search cases, how absurd it will be if the date of initiation of search is treated as the date of abatement of the proceedings. So the concept is the proceedings pending on the date of initiation of search, the date on which the search starts, the trigger point, all those proceedings will abate, will come to an end, and will be deemed to come to an end, and they will merge into the block assessments. Third important change is undisclosed income. The definition of undisclosed income has been drastically changed. There are 3 items which are there in undisclosed income. Generally what we understand about undisclosed income is something which I have not disclosed to the tax authority will become my undisclosed income. That's generally the concept, and that should be the theme of undisclosed income. But if we see the definition of 158B, it talks about 1 and 2 items. I have no problems because that talks about assets not disclosed. But look at the third item. Any expense, deduction or allowance claimed under this act that is found to be incorrect. In the earlier regime, if you would have seen, the concept was if the claim was found to be false. So there is a huge difference between a claim being found to be false vis-a-vis a claim being found to be incorrect. Incorrect can be based on interpretation. False is when you make a misleading claim. False will definitely fall within the definition of undisclosed income, but an incorrect claim cannot fall within the definition of undisclosed income. So that is a minor change which they have done, which again is going to lead to litigation.
Minor change but with major ramification.
It will have. Sir, abhi to we'll have see further sections, no, how it will unfold. You will find more further ramifications. Now let us see how the income is to be computed. The concept, the theme of the block period is everything will be included as part of the income, and then they will reduce what is disclosed in your tax returns. That is how your income which is taxable under the block period will be determined. So the definition, computation of total income of the block period has 5 elements. First, income disclosed in the return which you file in pursuant to a 158BC notice, which is a block return notice. So obviously you will normally people disclose the same income which you disclose in your earlier return. That is 158BC. Then second item is income as earlier assessed under 143(3), 147, etc., etc. Means assessed income. Third, income declared in return not covered by A and B. So for example, if your return is not subjected to assessment, that's the third item. Fourth is, in the case of a year of search for which you may not have filed your return of income, income which is incorporated as part of your regular books of accounts, that's the fourth item. And the fifth item is undisclosed income. Now, undisclosed income, as I refer to, this is the definition of undisclosed income. This will become item number 5 in the aggregation of your total income. What is also important to note over here is what can be the scope of undisclosed income, which are these 3 bullets. One is based on the evidence which is found during the course of search. Second, material or information available with the assessing officer, or material or information which may come to his notice from whatever source. So undisclosed income not necessarily restricted to your search material, but it can be based on information coming from any source. This is the aggregation. This will become your aggregate of the income of the block period. Now it will be reduced by, now kindly this is second bullet is very, very important. It will be reduced by item number B, C and D. B is your assessed income, C is your declared income, and D is your entries in your books of accounts. Now take an example. I'll just show you with the reference to an example and come back to this. Now take this example. I have filed my return of income, say, for 550 crores. Now the regular assessment was going on. Supposedly my search takes place in December 2024. And my regular assessment was going on for assessment at 24-25. So by virtue of the fiction of law, my regular assessment will abate. So my return is 50 crores, my regular assessment will abate, and it will now be formed part of my block assessment. Now this block assessment, supposedly in my return of income, I have made a claim of section 10 AA. The claim is, say for example, of 25 crores. We have referred to 10 crores or 25 crores, whatever is the quantum. Now that claim will be examined in your block assessment. Because your regular assessment has abated, it will now be examined as part of the block return. Supposingly there is a history why your claim is being disallowed in earlier years and you are litigating that issue. Despite that, assessing officer will follow the same view. He will make the disallowance and he will add it as part of your income of the block period. This is not your regular assessment. This is regular assessment merged into your block assessment. So it will form part of your income. So your 50 crores of income will become, say for example, the addition is made of another 50 crores, which are routine, which may have 2 components. One is denial of exemption of 10 crores. Second is a TP adjustment of 25 crores. And third may be 15 crores of search related assessments. So the search related addition is only 15 CR, but your total addition is 50 CR. Now the tax on this 50 CR will be 60%, which is 30 crores. That's the formula, because formula says income determined, which is 100 CR, minus the 3 components: income assessed, income returned, and the income as per books of accounts. When you reduce those 3 components, you come to the figure of 50 crores of addition for the block period. And for a block period, the tax rate is 60%, penalty is 50%. So this will be 60% tax and 50% penalty. Plus surcharge, they are still to notify. So it will be more than the quantum of the addition. So this is the absurdity. I understand that there are statements being made by the ministry that the intention is only to tax you on the undisclosed income. But when there is a concept of abatement, how this will work is again a larger issue. Because once there is a regular assessment which abates, obviously those addition will also become part of your block assessment. Either you have to provide for 2 tax rates, one for the addition made on the basis of search material, second additions which are routine additions. They will be 60%, other will be non-60%. But then again this will lead to another litigation, that is parallel assessment within the block assessment. And that is what they are trying to do away with. So this is the one absurdity which we could notice on the pure reading of the section itself. And this will get compounded because I can give multiple examples. Your regular 147 assessment is going on. That will abate. Those issues will merge into block assessment. 60% tax will be levied on those additions. So this is clearly a very, very, I would say, bad drafting in that sense. The concept of abatement could not have been brought into a block assessment. If they wanted to bring it into the block assessment, the tax rate cannot be more than 30% because it has to remain 30%. If your regular assessment, regular tax is 25% or 30%, you cannot have a rate more than 25 or 30% in a block assessment. Or the concept of merger cannot happen because once you merge the regular addition into the search assessments, you can't tax your regular assessment at a higher rate.
Look at 158 BB2. I think the point that you are making is that incorrect claim can also be subject of your total income. But if you look at 158 BB2, it talks of computed in accordance with the provisions of the Act on the basis of evidence found as a result of search or other documents and such other materials as are available with the assessing officer or come to his notice.
Or anything which comes to his
No,
notice.
or come to his notice during course of proceeding under this chapter. No, so the point that I am making, if it is only a difference of legal interpretation, leave aside the factual aspect. I don't think you can bring it as undisclosed income.
But then how will
No,
the
your
abated
point is well
proceedings?
taken. There is no other parallel proceeding.
There is no other parallel
parallel proceeding. The point is well taken.
Because
I think
they
this
could
is
have limited themselves to the first limb.
this is a mix and match
Correct.
of two different, absolutely different provisions.
Correct.
It's a
But that
wrong-
is why earlier the court said that there are parallel assessments. Block assessment was separate, regular assessment was separate.
Correct.
Earlier also 60% tax was levied on block assessment.
Correct.
But there were parallel assessments. So that was a separate regime, this was a separate regime. Now once you are merging it, you can't provide a same rate, uniform rate of taxation. That's where
just go back to the first slide. We'll put it in historical perspective. The first slide that you
there
showed.
where the comparison was done.
No, the scheme 158 BC and the first one that you showed.
This one?
Yes, So if you see the 158 BC and the 158 BD and Arun, a search in 2002, pending in the Supreme Court at admission stage. 20 years have passed. And there was those parallel proceedings. So 1/6/2003 to 31st March 2021, you had the 153 and 153C, where you also had the power to go before the Settlement Commission. And I don't know why that power was taken away, because the government could collect substantial taxes. And then they lost after the famous Kabul Chawla judgment, which said that it can be based only on incriminating material, which was confirmed by the Supreme Court in Abhisar. So now, in order to get over all of those, what is now sought to be done is mix and marry these two different provisions which have no commonality. So it's a rehash of two provisions which has resulted in this confused state, and they will not know what to do. Like Rohit said, you might invariably end up in a situation where you pay tax at 60% on the total income, which includes normal disallowances, which are not related to anything related to search.
Because the concept of abatement is there.
Correct, agreed.
You know, sir said mix and marry, and he again used the word confused. Now I can't resist myself. You know, once, this was when I was still contesting some elections, strategizing institute elections. That was some 7-8 years back. And I was telling, how do I convince the voters? So one of the guys in Pune, and we call him Chanakya, his forefathers used to be the advisors to Peshwas. And he told me, if you can't convince, confuse. That's a beautiful court craft which I have seen now being mastered by some of the senior advocates. I am not including Ajay ji among that. But if you ever see the court, if you are not able to convince the judges, confuse.
And there is another problem. As of now, we have only dealt with normal additions. There is one more clause which will create further problems. Now this section says, while computing your income, you will not be allowed benefit of losses. Not the current year losses, not the preceding year losses. So look at a situation where your income is being determined, your regular assessment has abated or 147 has abated. In a normal course, when the regular assessment additions are made, you are able to set off your current year losses as well as the preceding year losses. Now the law says benefit of losses of the current year will also not be given, and benefit of the carried forward losses also will not be given. So you will ultimately end up paying 60% tax on the additions on a gross basis without set off of your losses, which will be completely your unreal income. Because you have suffered losses, you are entitled to the benefit of those losses. Unobserved depreciation is also denied. brought forward unobserved depreciation, brought forward losses and current year losses. Current year losses obviously includes the depreciation also. So they have not separately included it. But everything is denied.
When the assessment abates, the assessment was already concluded. A concluded assessment will abate. What about pending appeals?
No, so that was, I'll come to that also. That's a bigger problem in case of non-such cases. Here also the same. Here they are saying that this will abate and it will be deemed to be abated.
No, so therefore either those appeals will become
Will
infructuous
become infructuous.
and you will have a fresh round
Correct.
of appeals.
Correct. Now this is in so far as the block assessment in case of such cases is concerned. This is just matter of procedure. So I will not spend too much time on this, which requires you to file return, etc., etc. Now come to a non-search case. Supposingly I am a search case. Neeraj is a non-search case. My search takes place in December 2024. His officer comes to know about it in December 2026. Now the law says his proceedings pending on the date of initiation of search will abate. So for his 24-25, if his order is passed in March 2025 and he is, resting that his order has been there, but in 2026 his officer will say, no, because there is a search which took place at someone else's office and your information was also found, so your earlier assessment which stands concluded stood abated automatically by virtue of law. Now I will reassess your income for that period also. December 2024, search takes place at my place. He is not even aware of this. He is no party to it. But some document, I may have entered into some transaction with him, which is a legitimate transaction. That information will be passed on to his officer in December 2026. By that time, all his assessments are over. But some proceedings were going on in December 24. So his office, by virtue of fiction of law, those concluded proceedings will be deemed to be have abated on the date of initiation of search, and he will have to go through the reassessments again as part of the block assessment. The illogic over here is, if you see the existing scheme of 153C, there what they did was, they said that the abatement will happen on the date of handing over of the documents. So this was not a problem in the existing scheme of 153C. But there other disputes arose in the context of abatement, which was in the form of Saksham commodities and Rojas, etc. Now they wanted to overrule those judgments. But in order to overrule those judgments, they have not realized that there is another blunder which is happening. That the concluded assessments, which the officer will come to know after 2 years or 3 years, they will also get abated and deemed to be abated. And the regular addition which already has happened will become part of block period, will be subjected to tax at 60%, surcharge, penalty, etc., etc. So this is another problem in case of one third person. Apart from all this process, this is an additional problem in case of another person.
Provisions that have been brought in are largely to negate, settled Supreme Court decisions.
Correct.
In the context of 158 BC, you had Blue Moon, you had Abhisar for 153A. For the 153C or 158 BD, you had Jasjit Singh. All these decisions are sought to be overruled by the draftsman now seeking to sit down and somehow marry, and I will not use the word mix and marry, somehow harmonize the two provisions that existed earlier in the statute and to make it one unified provision, which will again probably be hammered out in the courts.
I'm very curious, and I'm going to get my team to do this research at Taxutra that how many other countries, developing or developed, have these search and reassessment provisions. In the US, after some 7 or 8 years, a case has traveled to the Supreme Court. Can you believe it? And that was also on that constitutional validity of that taxing the passive income of corporations, global corporations, which passive income lying 8 years.
Those countries view search as an invasion of privacy. So they view it very seriously. They view it
But
very
sir, even
seriously.
reassessment, sir, taking a second shot at the cherry, how many countries would have reassessment provisions? I have no clue. I'm just wondering because reassessment is, it's like
No other country can match Indian taxpayers in genuinity. That you can also agree.
an Indian lawyers.
So this is just a comparative table what I was explaining to you. This just to show the absurdity in terms of numbers. Situation 1 and situation 3 are identical. The only difference is the same person has been subjected to search. Exactly same regular assessment going on. 30% on 120 crores he has to pay in the existing provision. But only because he has been subjected to search, he will be taxed at 60% on 140 CR, which includes 120 is a regular income plus 20 which is found during the course of search. So this 30 becomes 60 plus penalty at the rate of 50%. Similarly, situation 2 and situation 4 are identical. The only difference is that in between a search took place. So which is a regular assessment, 60%, 30% of 5 crores versus 60% of 25 CR plus penalty at the rate of 50%. So as sir also pointed out, these are amendments which are intended to, overrule the principles of Abhisar, Kabul Chawla, etc., etc. But in the process, the drafting and while they are trying to, consolidate the two schemes, there are problems, and unless resolved, this is going to be a big litigative issue as to how can a income be taxed at a higher rate, which is your disclosed income. So this is in the form of an example. We have explained the block period. Earlier, only the search year was included. Now the year of the search plus till the time the search is concluded, both that year also gets included. So in my example, 2 more years, 6 years plus 2 years become part of the block period.
Disputes will come to haunt where people challenge the initiation in 1 year and just because of a restraint under 132(3) you took it to a different month.
Correct.
If the 2 years get covered, people will challenge this.
So this will become a big issue.
Big
Till
issue,
now, the courts as used to say, what is the prejudice caused to you because of the the proceedings being continued. This is an additional prejudice which will cause because your 1 more year will also get included. So I'll move on to the next issue is Vivad se Vishwas. So broadly, this is the theme of block assessment. I'll not get going into nitty-gritties. We have given it as part of our slide deck. So if you have any queries, you can come back to us. Now this is Vivad se Vishwas scheme 2024. This I would say is a very welcome change in the sense earlier scheme of 2020 is being carried forward. So if you see the scheme, basically it is the same scheme, but in a little modified version. Broadly, the substance of the scheme is the same, that you can settle your pending litigation by going through this process of direct tax Vivad se Vishwas scheme. This is some data which we have pulled out from the source which is available in public domain, that in the earlier 2020 regime, there were almost 1,32,000 which forms were filed, and which involved a tax dispute of around 1 lakh crores, and out of which the government got 53,000 crores. So it's a huge number, and I think they are looking at some similar kind of a number in this 2024 scheme after the success of the 2020 scheme. This is broadly the scheme. One important change, what we have done is we have simply tabulated what is the old scheme and the new scheme. I will only highlight what is the change. The change is the second item, which is, we have crossed it in the new scheme to show the difference in the earlier scheme and the new scheme. Earlier, the scheme provided that supposingly your order is received, because the threshold date is 22nd of July 2024, when the budget came in 23rd July, so 1 day prior. So anything, the specified date is 22nd July for the purpose of eligibility, who can go before the direct tax Vivad se Vishwas scheme 2024. So this is their date, 22nd July. Now the earlier scheme also had a similar date. The earlier scheme provided that if on that specified date, the time for filing an appeal is pending, that taxpayer was also eligible to get its appeal or this issue settled under the Vivad se Vishwas scheme. That has been deleted in this scheme. So to give an example, supposedly an order is received, as an assessment order is received on 20th of July 2024. Now you have 30 days to file your appeal. In the earlier scheme, since the time limit for filing of appeal was there, you were eligible to go for direct tax Vivad se Vishwas scheme. But now the law says, law does not provide for this. So therefore, even if the time for filing the appeal is still there, technically you are not eligible. There seems to be no reason why they should have deleted it. One could have included this also, as was there in the earlier scheme. But I think there were some controversies with regard to miscellaneous applications, etc., also being treated as the time for filing of an appeal. Probably they want to cover those, but in that context, they have actually, denied a legitimate assessee also.
This can be successfully challenged as being discriminatory.
Correct.
Somebody who received an assessment order on, let us say, 15th of July, filed the appeal before 22nd.
Correct.
Somebody who's waiting to file the appeal within the statutory limitation. I think he is being discriminated against.
Clear case of Article 14, because same person, same date, everything same. The only difference is one has filed the appeal, one has not filed the appeal. So that is being discriminated. So the earlier date was 31st January 2020, which is mentioned, and now date is 22nd July 2024. One important aspect is the old appeals which are pending, which you did not go for resolution in 2020 scheme, can also become part of the new scheme. And I'll come to that also. Second is the definition of disputed tax. Just to point out, the only difference in the new scheme and the old scheme is arbitration is not covered, because in the earlier scheme the arbitration was also sought to be covered. Here the arbitration is not covered. Third is what is the tax rate? The tax rate in Vivad se Vishwas scheme is 50%. In case you have lost, it is your appeal before a particular forum, then it is 100% of the disputed tax. And if you have lost, if you have won and the department is in appeal, then 50% of the disputed tax. And if you pay it within a particular date, then it is 100%, and if you pay after that date, it is 110%. So 10% additional for delay in resolving or making the payment under the Vivad se Vishwas scheme. This was an identical provision under the old 2020 scheme also. What I have also wanted to highlight was the declare. Correct. In fact, this scheme specifically talks about the matters which you could have taken in the 2020 scheme, but you did not. So there can be two possibilities on those kind of matters. So for example, earlier in 2020, your appeal may be pending, say, before tribunal. Now it may have gone, either it is pending before the tribunal itself, or the second situation will be it has gone to the next level, which is the High Court. Both assessees can go. The only difference is in the first case where the appeal is still pending before the ITAT, they have to pay 10% higher tax. In case person who has moved on to the High Court, it will be a lower tax, it will be regular tax. So that's the only difference. But they have permitted those taxpayers also to go for resolution under the direct to web tax Vivad se Vishwas scheme. Yes. So it is like, why you did not go for earlier scheme, we are permitting you, but with a little bit higher tax. So that is what we have tabulated over here also. 5 or 10% is the additional which is to be paid. Such case, earlier it was permitted to be resolved under direct tax Vivad se Vishwas scheme, but up to 5 crores. Now under the new 2024 scheme, such cases are not eligible for resolution. And this is the provision relating to arbitration which has been deleted. This is such, so we can leave out all this.
Rohit made a Freudian slip. मतलब गलती से such आ जाता है. That's the Freudian slip. So he said in between Vivad se Vivad scheme. So that we can rename it that Vivad se Vivad. There's this old movie again, 89, Kayamat se Kayamat tak. विवाद से विवाद तक.
So these are some of our comments and observations which I just highlighted on the screen. These are all old issues. There are some FAQs which have been issued. So for example, 263 appeals, 263 matters, they can be resolved also under the scheme. In that situation, whatever is the finding of that CIT under 263, that will be treated as the tax payable, and in that situation you can get it resolved under a VSV.
Just two observations. One which I don't agree with Rohit. He said 53,000 crore is a huge amount. Let's wish that 5 lakh crore is collected. You see, I was told by one of the management gurus that what is a great decision? One which has multiple outcomes. If you get 5 lakh crore out of Vivad Se Vishwas, A, you'll kill litigation, at least that 15 years will become 10 or 5. Number two, the individual tax rate from 35% can come down to 20%. So 53,000 crore, very honestly, is nothing, which you'll anyway end up collecting now, today or tomorrow. Ideally, it should be much, much more. It's 3% of the gross, of the net tax collection.
No, I think, Arun, you are not right. That 53,000 crores, you don't know which way it will go.
That's true.
Right. So therefore, now the assessee has taken a hedge. The assessee says the interest, suppose the assessee has lost. The assessee says the interest and penalty is being waived. So I might as well, pay just the tax and be done with. Or in a departmental appeal, he pays 50% and he is done with. So he is not risking the outcome of the litigation.
Sure.
And plus the time that is involved,
Agreed.
the cost that is involved.
I think so, but fundamentally, you got to, as a government, when a policy maker, are you looking at Vivad Se Vishwas as a litigation cleanup scheme? Are you looking at it as an amnesty scheme, or you're looking at a tax collection scheme? If I were a policy maker, I would look at it as a litigation cleanup scheme. I would have looked at it.
That's the first objective.
Yeah.
That's the first objective.
Then
I think the collection is incidental.
But every 3 or 4 years, if you're going to have these amnesty schemes,
No,
really,
see this in the light of and coupled with the raising of monetary limits. So here the assessee has a chance to withdraw. Raising of monetary limits or filing of appeals by the department is another cleanup exercise. So matters which are filed in court plus the fresh filing will have to adhere to the increased monetary limits. So the limit for the High Court has gone up from 1 crore to 2 crores.
Supreme Court to
2
5.
crores to 5 crores. So there may be so many appeals pending filed by the department in the Supreme Court which will have to be withdrawn once this limit of 5 crores is put into place.
Sure.
Similarly in the High Court. So it will declog the system, and here the assessees are given a chance to withdraw their pending appeals, again which will reduce and declog the system.
True.
So I think that's the larger objective. That's the larger objective according to me. And you can't bring an amnesty scheme, I think, based on the assurance that was given sometime to the Supreme Court sometime in
But 8 saal ho gaya, sir. 2016 mein we had IDS. Just before demonetization.
But that was not a proper amnesty. I don't think that was an amnesty.
And that is what, in fact, the last bullet of the slide is what sir was
I can tell you
pointing.
with some confidence, one taxpayer in Maharashtra declared almost 1,000 crores in that scheme, which became quite well known.
So this is the last bullet. So sir was referring to the increased limits. So while you are deciding to go for a resolution under a direct tax Vivad Se Vishwas scheme, one will have to take care, because in case you are falling below the threshold, you need not get it resolved, because in that case also you will have to pay 50% of tax. So that's the last bullet as a word of caution, that in case the department appeal which is pending in your case is below the threshold, then you need not get it resolved under VSV, they will have to withdraw it. And this is an example to show the absurdity. In fact, the absurdity which we are trying to reflect in this is, there are many cases where the department files an appeal beyond the time limit. So, for example, 22nd July 2024 is mentioned as the threshold date. Now, supposingly the department ought to have filed the appeal by that date, but they did not file it for whatever reason, and that we all know that they filed those appeals with delay, 100 days delay, 50 days delay, and the appeal is filed, say for example, on 31st of August. technically you are not eligible for that resolution under VSV. But in a similarly placed assessee, in whose case the department would have filed appeal in time before 22nd July, he will be eligible. So because of the inaction or the delay on the part of the revenue, you are getting prejudice of not getting your issue resolved under the VSV. That again, one issue which we have flagged. Another issue which of course we will raise through various forums, we raised it in the last scheme also, is reassessment. Now reassessments are not permitted. So for example, a notice is issued to you which contains reasons of escapement of income. Technically you cannot get it resolved under VSV. But now with the order being passed under 148A(d) or 148A(3), we will be filing a representation that if that can also be covered. So in some of the taxpayers may want to get those issues also resolved through the VSV scheme, where there is no order, final order, but there is an order under 148A(d) or 148A(3). Of course, it will be D only, not 3, because 3 will come into force in future.
There will be no pending appeal in this case.
So therefore, there will have to be an amendment to say that even this will be regarded as a pending proceeding.
But here it talks of pending appeal.
As of now, the provision does not permit. As of now, it does not permit. So this is broadly is the Vivasya Vishwas. Rest all is all charitable trust, etc. If you want, because we are running against time, I don't know whether.
I think can we take indirect taxes? Would
Yes.
that be better? The substantive amendments have been dealt with. A big hand to Neeraj and Rohit for wonderful presentation.
Thank you, everyone.
Wonderful.
So Rohit, Rahul. So if we can have a quick comment on this 37(1) amendment,
Settlement.
Yeah, settlement.
This is settlement as per law.
Yeah, the 37(1) is, it's a general allowance provision which is become a general disallowance provision.
Correct. No, so basically this, I think this is intended to more do with, pharmaceutical companies where the settlement takes place. The law is now very widely worded. I'll just highlight. Which clause?
It says to settle proceedings initiated in relation to contravention under such law as may be notified by the central government in the official gazette. So this is yet to be notified. So it will be under a specific law, not general settlement.
Like a general overcharge.
That they will have to notify. So today it will be premature to comment on this.
That it is not a violation of law.
Right.
But now they can notify that it is a violation of law.
Correct.
So, in explanation,
Maybe probably get fight now.
Right.
so in explanation 3 to section 37, compounding was already covered. Compounding of a contravention of law. Now, settlement per se, the payment made for settlement of a on account of contravention of law, that was not covered. So now, but that needs to be notified as per the. So only those cases where it is notified, it will get covered. Otherwise, cases in court cases, such payments have been held to be deductible. So maybe I'll invite Shami Kapoor and his team for indirect tax.
So good afternoon, everyone. So I'll keep it short and. Hold on. This one.
Welcome.
Yeah. So as we are all aware, the union budget essentially is the first screening of the trailer that comes on the GST Council. So what I mean is that where the council recommends, the union budget is the first glimpse into the text of the changes that would happen by way of those recommendations. I would, skip the changes in customs and excise because most of those are housekeeping changes and are not that substantive, and quickly go to GST, in which I would like to touch upon on 5 or 6 substantive amendments. So the first one is in clause 112, which basically has introduced a new section 11A, which provides the power to the government that where the council recommends that there is a trade practice which by way of which tax is not being collected, the government can notify that recovery would not occur in those cases. This is a very welcome change, and the application of that is yet to be seen, but few of the cases that comes to mind are the gambling and online gambling and casino cases, where the industry has pled that the tax has not been paid due to trade practices, and if the tax is now recovered, then it would virtually mean shutting down those industries. So probably it has been introduced for something like that. The other industry that comes to mind is insurance, in which again there are certain trade practices because of which on marketing related payments tax is not paid. So even in that case, maybe this section will find application. The other
This has been adopted from the Excise Act. It was already there in the Excise Act. So they have adopted that now from excise into the GST.
Right.
So, of course, insurance is one very good example. And they have brought in that amendment in the insurance sector that when between the lead insurer and the co-insurer, actually the trade practice was that they were not collecting any tax. And therefore now they have brought in that amendment saying that it is not a supply of goods, neither a supply of goods, neither a supply of service. So therefore an amendment has been brought in, and it has been now part of Schedule 3 as far as the amended part. Was I not? Was it okay? Yeah.
So another welcome change is in clause 114, which is that where and this is a very welcome change that basically provides that if till 2021 there were discrepancies in you reporting the credit, as long as you have filed your by way of returns till November 2021, that credit will not be disputed. So this formed parts of a lot of disputes under section 73 of the CGST and state GST acts, and therefore this is definitely going to be a much welcome change for assessees.
Well, in this, a lot of companies had, filed the cases before first appellate, and also writs were filed. So this is really a welcome change, because initially when GST was brought in, there was a lot of problem faced by industry at large. So by bringing in this amendment for these 4 years, if the returns were filed late due to whatever reasons, so for 17, 18, 18, 19, 19, 20 and 2021, the benefit has now been given. But it should be filed up to, the amendments should have been brought in till November of 2021.
Yes. So the other one which I would like to touch upon is clause 115, and in that this is quite interesting. What the proposal is that if tax is being paid after a recovery notice of section 74, the credit would be barred only for till 2021. Now it is interesting to note that 74 is here on forward going to be replaced by a new section 74A. So that begs the question whether a recovery action under 74A would not bar the credit. So that is something that would be required to be seen, whether a fresh amendment is brought in after this, but looking at this, at this current point of time, it appears that that might be the intent.
Yeah, but 73, 74 per se remains, though from 1st April 2024, it merges into a new provision 74A per se. So 73, 74 initiation or recovery under those provisions would be effective till 31st March of 2024. In
Right,
any case.
right. So I was talking about the period going forward.
Going forward, yeah,
Yeah.
right.
So the next one is we would like to touch upon is clause 131, which talks about a new subsection being added in relation to summons proceedings, and it says that an authorized representative would be can be allowed to appear in summons proceedings where the proper officer allows such authorized representative to appear. Now, this was kind of required, but this has also, created certain issues. The requirement was because your investigating agencies like DGGI, they were randomly issuing summons notices to CXOs and top level executives. Now, this kind of creates the space that the CXOs can actually authorize another officer of the company to go and attend that summons. However, what is interesting to note is that the provision uses the word authorized representative, which has been defined under the Act, and that includes an advocate as well. But in my view, that cannot be the intent, because the Supreme Court has itself held that in a summons proceedings, a lawyer cannot substitute the person who is being examined. Your thoughts on this?
Correct. I think that was also discussed by Mumbai High Court on one of the judgments. This was much sought of because a lot of notices which were being issued by DGGI were issued to the top management, and top management are not very knowing the day-to-day affairs. Based on that, I think this amendment has been brought forth, and it's a welcome amendment, because the authorized representative here, of course, what Arnab is saying is already defined, that it may be a chartered accountant or a lawyer, but it is subject to the discretion of the proper officer. So that's also, a caveat.
Yeah,
which has been brought forth.
It looks like that this will just add on to more.
Correct.
Add on to more litigation on
Correct.
this area.
Correct.
So, keeping with the theme of reducing litigation now, I guess one of the most important changes is the new section 74A, which is being introduced by way of this union budget, and this essentially provides an unified provision for assessment rather than keeping two separate provisions for cases where there has been a failure to pay tax and where there has been an evasion to pay tax. Evasion would include suppression, statement fraud, etc. So, the existing provisions, you were creating a lot of issues because there were two separate timelines provided, and it would happen that the state authorities would begin an investigation in 73 on the same issue, and the center would begin an investigation under section 74. They would get merged, and the result would be a haphazardly created notice. This, and in a way, solves that problem. What is also interesting to note is that the timelines have been crunched, and this is showing that the revenue has become mature, that they have reduced the timeline themselves. So the total timeline to issue the order remains substantively same, which is 5 years from the time period of filing the annual return. However, what is interesting to note is that earlier they could have issued the show cause notice 3 months before that date. Now, rather doing that, they are saying, what they proposed is that within 42 months you can issue the show cause notice. So virtually that creates a much larger space to complete the adjudication process. What we were seeing was that there was only 3 months time period which was being provided for adjudicating the show cause notice, which is woefully short for filing replies, cross-examinations, examination of documents, and then issuance of order. So therefore, this is again a welcome change.
Correct.
So there are certain changes in the amounts that has also happened. So you would see that this is a table that we have compiled. So in cases of fraud and suppression, what is being proposed is that the penalty would be reduced on the basis of the time period by which the tax, interest and penalty is completely paid. So other than that, we just would like to touch upon the mini amnesty scheme that is being used by your clause 142 for cases where there has been a failure to pay tax rather than evasion of tax. And in those cases, what is being proposed is if the tax amount is paid till 2020, for the period till 2020, before a particular date, and the appeal or writ petition or any other dispute is withdrawn by the assessee, then in that case, interest and penalty would be waived off. The actual contours of this is awaited, but again, a move which appears that the revenue is working towards the direction of reducing litigation, which is also underscored by the point that in all cases that tribunals have not been even constituted. So it rather appears as a step taken in the direction of mitigating that. Your comments?
Yeah, so the intent of the government, even in the direct tax or in the indirect tax, is to reduce litigation. And as I earlier also said, the earlier 3-4 years were quite topsy-turvy for GST for many of the companies. So now they have come out with this kind of an amendment, which by virtue of which, for the 3 years, 17, 18, 18, 19, 19, 20, if there is a notice issued under 73 and it's pending, then you can pay the tax, and maybe the interest and penalty, what they are saying, would not be levied. So that's a welcome, amendment.
Yeah. So even if you've gone in appeal, you can withdraw it. The proposal is you can withdraw it and then go in.
I think they will be giving that. There was a timeline of 31st March of 2025, so it has to be clarified.
Sure. I think that's all. The other changes are there in the deck. So if there are any other questions in relation to any other changes or these, please feel free to reach us. Thank you. Yes.
Then it is not to be. No, it can't be refunded.
Cannot take refund for that.
That's very clear, sir. I think whatever has been paid has been paid.
Which is in line with all indirect tax amnesty schemes in the past as well.
So GST law in any case is evolving till today, and GST Appellate Tribunal is yet to be formed. We hope that by 1st August, the Appellate Tribunal would be formed. The President has been appointed, and the state GST would also be coming in, So therefore, but though there are a lot of cases which are pending, we hope that when the Appellate Tribunal is formed, maybe the High Court may be reduced with the litigation that is already there. Thank you so very much. If you have any questions, please come back to us, sir. Thank you so much.
Thank you. And refreshments. I think it's being served outside as we speak. Thank you.